comes on.
Suerte, querido.
¿Cómo estás?
¿Cómo estás?
Gusto.
Todo bien. Perfecto. Dormí 7 horas, estoy perfecto.
No, porque
Ayer fue una pesadilla.
llegaste tardísimo.
Llegué a las 3 de la mañana, me acosté, no dormí, obvio, pero descansé un poco los ojos y me vine aquí a las 7:30. Se atrasó el vuelo. Se atrasó el vuelo 6 horas. Por el clima. Por lo menos llegué.
Buenos días a todos y a todas. Bienvenidos a este segundo día de audiencia sobre emergencia climática y derechos.
Good morning. Please take your seats. We're going to resume with this public hearing. Please take your belongings from the empty chairs so that they may be used by other participants. Please be reminded about the setting up of the front table. The first few rows are reserved on the left. They are reserved for the delegations that are currently speaking for each session. And once they're done, they will be replaced by those participating in the next block of participants. Please be reminded that the delegations that are going to participate now are to come in half an hour early so that they can be directed to their seats, and an explanation can be given about microphones and interpretation. The interpretation equipment, both the mobile phones and the equipment that is being provided in the room, must be on for them to work. If the screen goes off, you will no longer be able to hear the interpretation. That's the reason why some of you have stopped hearing the interpretation during the hearing, and that happened yesterday. This hearing is being broadcast live on all media, social media of the court in Spanish, and they're also available on YouTube, and all of the information is there on our website. And if you have any questions or any concerns, please approach the staff of the Secretariat so that they can help you with anything you need. Thank you for your attention, and we will resume this hearing shortly.
Señoras y señores, de pie, por favor.
All rise. The court. Good morning. This hearing is called to order on in the matter of the request for an advisory opinion submitted by the Republic of Chile and the Republic of Colombia. I would like to extend a warm welcome to all those appearing before the court during this second day of hearings, and I'd like to thank you on behalf of the court for your interest in these proceedings. I would like to now give the floor to the registrar to issue the necessary instructions about the proceedings today. You have the floor, sir. Thank you, Madam President. Today, this morning, we will be hearing from the following institutions: International Union for Conservation of Nature. The second group is the Center for Human Rights and the Environment, and FACE, Fast Action on Climate to Ensure Intergenerational Justice. Number 3, our Children's Trust University Network for Human Rights and Mexican Center for the Defense of the Environment. Number 4, Center for International Environmental Law, New York University Climate Law Accelerator, Greenpeace International, Open Society Justice Initiative, and Union of Concerned Scientists. We will also hear from the lawyer Jorge Calderon Gamboa and the Center for Democratic and Environmental Rights, University College London Public International Law Pro Bono Project, Cornell Law School, Professor Dinah Shelton, and Soledad Garcia Munoz and Erin Daly. Thank you, Madam President. And also, I would like to remind all those appearing before the court to speak slowly and clearly to facilitate the work of the interpreters. And whoever speaks, please identify yourselves so that we know who is speaking. Thank you, Madam President. Thank you, Registrar. As per the order previously agreed, now we will hear from the representatives of the International Union for Conservation of Nature. You have the floor.
Good morning, Madam President, distinguished members of the court. It is a great honor to be here and appear before you on behalf of the International Union for the Conservation of Nature. IUCN is the world's oldest international organization for nature protection, and we would like to thank the court for this opportunity. My name is Christina Voit, and I am the chair of the IUCN World Commission on Environmental Law. Madam President, distinguished members of the court, the task before you is without doubt a very important one. The whole world is watching, but it is not a difficult one. It is not a difficult task because the why, the what, and the how of states' obligations to prevent climate change impacts on human rights are clear. And I will address these 3 points. First, to the why. Climate change impacts on human rights can already be observed, be it in the form of droughts, floods, wildfires, hurricanes, sea level rise, that affect rights to life, personal integrity, or to a healthy environment. But it is the projected future impacts and their cumulative effects, if warming continues, that need to deeply worry us. Because these projected impacts will be worse. They will be worse for individuals and groups that are already vulnerable. They will be worse for those that are young today or not yet born. And they will be worse for nature and ecosystems that will not be able to adapt and will collapse. These impacts are also mutually reinforcing and can lead to reaching tipping points where change will be irreversible and basically all bets are off. Second, to what needs to be done. Climate change can no longer be avoided. It can only be limited. The question, therefore, is how much global warming is acceptable? And this how much has been agreed to by global consensus in Article 2 of the Paris Agreement as limiting temperature increases to 1.5 degrees, which is a critical threshold with real biophysical and severe human rights consequences if surpassed. And this must guide our understanding of the obligations under the American Convention, which is not set in stone, but develops progressively and does not exist in isolation, but needs to be read together with other international law, especially the Paris Agreement. And third, how to stay within that 1.5 degree threshold. 195 states in Dubai last year recognized that limiting global warming to 1.5 degrees requires deep, rapid, and sustained reductions in global greenhouse gas emissions of 43% in 2030, 60% in 2035, and reaching net zero CO2 emissions or carbon neutrality by 2050. And it is these carbon neutrality pathways that need to inform human rights obligations. This does not mean that every single state must have a carbon neutrality target for 2050. No. It means that in order to reach global carbon neutrality by 2050, those states with higher capacities and higher responsibilities need to cut their emissions much earlier and deeper to net zero, so that those states with less capacity can also get there by mid-century. And this is in line with the principle of common but differentiated responsibilities and respective capabilities in light of different national circumstances. This is also in line with the principle of cooperation. Honorable Judge Perez Manrique asked yesterday about the threshold to evaluate the conduct of states. Now, the Paris Agreement provides the answer. Under the agreement, every party must have an NDC which will represent a progression beyond the party's current NDC and reflect its highest possible ambition in light of CBDR. These elements are due diligence standards, which will be relevant when next year all parties must communicate a new NDC by February 10th at the latest. Parties' next NDCs and corresponding domestic policies also must be informed by the outcome of the global stocktake from Dubai. Importantly, these elements are core to the repeating 5-year cycles under the Paris Agreement, which are purpose-built to increase ambition over time and are the most important aspect of the agreement. In sum, states must take immediate and progressive action at the level of their highest possible ambition to set adequate goals to reach global carbon neutrality by mid-century. This must be based on a comprehensive assessment of all mitigation options in all relevant sectors, including also imported and exported emissions. This also requires measures to conserve, protect, and restore nature and ecosystems. To this effect, states have positive obligations under the American Convention to adopt, apply, and enforce timely and effective mitigation and adaptation measures. I thank you and kindly request to give the floor to my colleague, Mrs. de Wind.
Honorable President, honorable judges, members of the Secretariat, friends, ladies and gentlemen, my name is Claudia de Wi. I am on the board of directors of the Environmental Commission Board, together with my colleague on behalf of IUCN. Multiple rights are affected by the climate emergency, rights that are protected by the American Convention. The actions meant to stop and curtail climate effects are also meant to protect human rights. The guarantee of the right to a healthy environment also hinges on compliance with the ultimate goal of the UNFCCC within a sufficient period of time for ecosystems to adapt. Demanding environmental protection is an appropriate way to guarantee other human rights. As we saw in the case of La Oroja, and OC23 is a basis and a roadmap about the rights and obligations of the convention and how they should be interpreted in light of the climate emergency. Individual and collective obligations under the convention are based on protection, respect, and guarantee of human rights. These are obligations of means and outcome. The states are under the immediate obligation to respond to prevent the violation of rights and using all the means available to them to prevent activities under their jurisdiction from causing significant damage. This obligation, as was mentioned by Dr. Voit, is a standard of due diligence which must be appropriate and proportional to the degree of damage risk. Yesterday, we heard about imminent danger in the case of Urgenda, and compliance actions, be them positive or negative, must be determined by each right. For example, based on the criteria for the assessment of progress according to the Protocol of El Salvador and the protocol itself. These include regular improvement and review of laws and politics based on the best science available, assessment of policies to prevent greater damage from happening. The obligation to take all positive steps possible is a continuing duty and is based on the obligations under Article 2 of the International Covenant on Civil and Political Rights, General Comment 31, and even the case of the Torres Strait in Australia. The Convention does not impose any express territorial constraints on the obligation to respect rights. Acting with due diligence means preventing environmental, transport, cross-border damages, and also human rights violations as a standard of care and compliance with substantive and procedural obligations. This includes having environmental protection plans, contingency plans, overseeing and controlling activities that may interfere with nature, mitigating and guaranteeing procedural rights to access information, participation, and justice. The principle of non-regression, progression, and prevention, precaution and mitigation of damages, as well as cooperation among states, must guide the compliance with this obligation. States are under the responsibility to mitigate damages caused by private actions, including providing appropriate compensation for human rights violations victims and due diligence to ensure that these violations do not go unpunished. So repairing through cooperation. We have examples in the inter-American system, such as the Inter-American Plan on Action on Climate Action, recently adopted by the OAS in the Bahamas last year. Madam President, climate change in our region has a human face. We continue to be the most unequal region in the planet, and this increases widespread poverty and also increases and creates new vulnerabilities. It's a vicious circle that calls for differentiated response, and the duties of the state are exacerbated in the light of the behavior of third parties. In conclusion, the task before this court is important but not difficult, as Dr. Voit said, and it is to interpret the San Jose agreement in light of environmental light, the corpus juris, and international jus cogens, but also bearing in mind the judicial guarantees and protection established in the convention and the priorities of the 2030 program, nature program of IUCN, persons and climate.
Thank you for your contribution. I will now recognize the representatives of the Center for Human Rights and Environment and Fast Action on Climate to Ensure Intergenerational Justice. Please proceed.
Thank you. Madam President, honorable judges, thank thank you for your time and attention to this critical matter. My name is Samantha Durksen from Hausfeld, and I'm here on behalf of FACE and CHRE, who submitted an amicus brief on behalf of a broad youth coalition. To complement the critically important legal arguments that we have heard so far, we believe it is essential for your honors to also hear directly from those who will bear the brunt of the consequences of climate change, and those people are the youth of Latin America and the Caribbean. They will address you now, first Giovanna, then Laura, and then I will follow with the legal arguments most important to the youth.
Dear honorable judges, a pleasant good morning to you all. Thank you for this historical opportunity. My name is Giovanna Hostialek, and I'm an 18-year-old youth climate activist and school teacher from Grenada. I see the effects of climate change around me every day, and I fear how much worse they will get. The Carenage and the town of St. George's is only one of the many areas of Grenada that has many businesses, homes, and tourist sites. In recent times at high tide, the sea level has risen to the point where the water is lapping into the streets, and it's an issue that we cannot mitigate against. Grenada, much like every other Caribbean country, heavily relies on tourism for its income. And with the tide, and if the tides keep rising, our beaches too will be submerged, ruining one of our main tourist attractions and forcing people to flee their homes and go elsewhere. The rising tides not only affect Grenada and the Caribbean, but all over the globe. An example that is very close to me is the rising sea levels in Carriacou, our sister island. The sea level has risen so much that the waves are washing away the graves of their ancestors. I can't imagine not being able to go and pay respects to those who have come before me. It is a heartbreaking reality that so many people are going through. With climate change comes unpredictable weather patterns, especially lengthy dry seasons and unbearable heat. Without rain, people in the northern parts of my country struggle to get water, and even urban houses that live on top of the hills have problems getting water too. My family has this problem every dry season that requires us to go to my grandmother's house to try and get some water. And don't even get me started on the unbearable heat. I'm a teacher, and having to stand up in a hot classroom with my students sweating like crazy is an uncomfortable experience. And I can't even fathom how much worse it's going to get, and that many people around the world are already experiencing it. I'm quite sure a few of you in this room have kids, if not grandkids. Have you ever tried to explain to them a movie or cartoon that you watched when you were young, but they are left clueless, and you believe that they missed out the best parts of life? Take that thought now and put it towards the wonderful experiences of our world. Would you like to know that your kids and grandkids will not be able to experience the joys that this beautiful planet has to offer? I don't want to have to explain to my kids or grandkids what a butterfly was, or that there used to be many green trees all around and that there were fish in the sea. I want them to have to come to me all excited to tell me the adventures that they had of going to climb mango trees to pick Julie mango, or diving to see the fish at the coral reefs. These experiences are priceless and precious, and we need to preserve our planet to allow today's youth and future generations a chance to thrive in a beautiful, sustainable world. We are scared of the rising tides, the unbearable heat, the devastating impacts that science is clear on, and the burdens left on us youth of today and tomorrow. We cannot have a tomorrow if we do not do the necessary work today. We cannot wait any longer for climate action. Thank you.
Please bear with us. We'd like to hear you from Laura as well.
Honorable judges, thank you for the opportunity to be heard and included in this historical process. My name is Laura Serna Mosquera, lawyer and climate activist from Colombia. The submissions by FACE and CHRE was a collaborative effort among more than 30 youth organizations from 12 countries, 5 indigenous communities, and a number of regional and global coalitions working for intergenerational justice and climate justice. As you well know, this climate emergency represents an imminent human rights crisis for both current and future generations, with disproportionate effects and no guarantees for a just and healthy future. We, who have contributed the least to climate change, are the ones who face its effects most directly, and that is why it is essential to close these intergenerational gaps. We appreciate the Court's commitment to allowing youth voices. We hope that our message will resonate in your decision-making. We ask that this Court would consider that states are obligated to implement urgently the message set forth in our youth submission, including mitigation and adaptation measures to curb warming in the near term. We are not prepared for what lies ahead without ambitious action, and we are the last generation that can act now. Youth activism is not just a response to the crisis, but is also an opportunity to generate innovative solutions that facilitate mitigation, adaptation, and promote resilience and intensify the call for change. Thank you.
Thank you, Giovanna and Laura. Honorable judges, for the planet and its current and future generations, especially in Latin America and the Caribbean, time is short. To prevent large-scale human rights infringements, to prevent surpassing irreversible climate tipping points, and to prevent passing on a degraded and severely depleted planet to future generations, states must act now. And they must act both to control climate change in the long run, as well as to slow the rate of warming in the near term. This Court has previously recognized the critical importance of the protection of the environment, as well as states' obligations to ensure intergenerational justice by preserving the environment, including by preventing irreversible harm. What this means with respect to the climate emergency is that states must take mitigation action now to prevent large-scale irreversible damage. The planet is heating fast, and the science shows that we are dangerously close to tipping points that will lead to large-scale irreversible climate changes, and as a result, serious and large-scale infringements of human rights of both current and future generations. As the scientific consensus recognizes, if warming breaches what is referred to as the 1.5 degrees Celsius guardrail, the risk of such irreversible tipping points increases in a significant manner. The science also shows that breaching this 1.5 guardrail may already be inevitable. And it is therefore essential that the rate of warming is slowed in the near term. Cutting CO2 is absolutely critical in our long-term fight against climate change. And measures to cut CO2 must be implemented urgently. But the cooling effects of CO2 measures will only be felt in the longer term. And it is for that reason that it is critical that states also urgently take action with respect to fast mitigation. And fast mitigation impacts the rate of warming in the near term and includes the cutting of short-lived climate pollutants, especially methane, and the protection of natural carbon sinks like the Amazon. I want to be clear, the 1.5 degrees Celsius is a guardrail. It is not a target. Even at 1.5 degrees, there will be severe infringements of human rights. States must therefore also urgently take adaptation measures, and in the longer term, states must take measures to restore the climate and bring warming down even further than 1.5. But such long-term plans cannot substitute fast mitigation as a necessary response to the climate emergency and severe risks of irreversible harm that we are currently facing. The youth ask that this Court interpret states' human rights obligations in a concrete manner. The European Court of Human Rights recently published an important decision that held that Switzerland violated its human rights obligations by not mitigating climate change sufficiently. The court held that the European human rights obligations required states to take mitigation measures consistent with reaching net neutrality in the next 3 decades, take immediate action, and set adequate intermediate reduction goals leading to net neutrality in the next 3 decades. These findings were absolutely critical, but the decision also had its limitations. The European Court remained largely silent on the concrete measures that Switzerland was to take to comply with these obligations, leaving it up to the state itself and the Committee of Ministers to fill in the blanks. This approach creates too much uncertainty, and given the emergency that we are in and the urgently required long overdue action by states, we ask that this court advises states concretely on their far-reaching mitigation measures that they must urgently take including fast mitigation measures. What states do in the very near term impacts the stability of the climate system for both current and future generations. And this court is in a unique position where it can declare concretely and definitively what states are required to do. Honorable judges, I thank you very much for your time and attention.
Muchas gracias.
Thank you to your organization for your contribution. I now give the floor to our Children's Trust, the University Network for Human Rights, and Centro Mexicano para la Defensa del Medio Ambiente. You have the floor.
Members of the court and respected members of the audience, my name is Kelly Matheson. I am the Deputy Director of Global Climate Litigation for Our Children's Trust. I am here with Kala Lapa Ikunanala Winter, one of the 21 youth signatories on the amicus brief we submitted along with the University Network of Human Rights and Centro Mexicano para la Defensa del Medio Ambiente. We are here with the support of 18 pediatric associations representing over 1 million medical professionals in more than 120 countries. I now give the floor to Ms. Winter.
Honorable members of the court, aloha mai kako, oa o Kalalapi Kuanalu Winter. Hello everyone, my name is Kalalapi Kuanalu Winter. I'm 20 years old and I am a native Hawaiian Kia'i Aina, which means land and water protector. Along with being one of the 21 youth signatories, I'm the oldest plaintiff in the climate case in Hawaii, in which I and 13 children aged 9 through 18 argue that the Hawaii Department of Transportation is illegally emitting excessive levels of greenhouse gases, which is violating our state constitutional rights. I'm here today to fight for the rights of children and all future generations to live healthful, safe, and happy lives, to allow the children to be children. I am a child of the lands of Ha'ena Kauai and Haleiwa Oahu. My community is deeply connected to our lands and waterways, and we rely on them to survive. The climate crisis affects our native lifeways every day. It impacts our indigenous traditions of feeding ourselves from our ocean as we always have. Rising ocean temperatures have caused mass coral bleaching and reduced the abundance of limu, an edible seaweed, both of which are key components to healthy reefs. Every time I go into our oceans, it breaks my heart to see how the climate crisis has devastated our marine ecosystems. Sea level rise has eroded the roads that we rely on. Increasingly frequent and dangerous storms threaten our very survival. In 2018, our community experienced 55 inches, or 1.5 meters of rainfall, in less than 24 hours. It was one of the most extreme flooding events in Hawaii's recorded history, and set a U.S. record for 24-hour rainfall. This climate crisis-induced rain bomb destroyed our community, including homes, farmland, and the Limuhuli Stream, our main water source. It cut off our only road-based access for almost a year and depleted our fisheries right when our people needed them the most. My story is not unique. All of the other youth signatories have experienced trauma, harm, and loss due to the climate crisis. Kaliko, a 13-year-old native Hawaiian, left her house for the last time in 2018 as Tropical Storm Olivia became the first tropical cyclone to make landfall in Maui. Intense flooding during the storm destroyed Kaliko's home, lifting it off its foundation and washing it downstream. As she fled, Kaliko saw other children fighting for their lives, standing on their roofs so they wouldn't get washed away. No child should have to experience that. Yet, it wasn't the only climate-induced trauma that Kaliko experienced. Last year, Kaliko lost her home again, this time as a result of the deadliest U.S. wildfire in more than a century. How many more climate crisis-induced disasters need to happen before decision-makers realize the urgency of the problem? Like many children experiencing life-threatening events caused by climate change, Kaliko, I, and all of the other youth signatories are infuriated to see how slowly governments are reacting. The harm we experience will only become more severe and irreversible without science-based action to address climate change. We need action, and we need it now. We simply have no other choice. Thank you, Your Honors. I now give the floor back to Ms. Matheson.
Your Honors, yesterday, this court asked if states must go beyond their current mitigation commitments to protect human rights, and if so, what is sufficient and necessary? We address this question. This court has a pivotal opportunity to set a mitigation standard, and in so doing, amici urge that this court adopt 3 bedrock principles. First, best available science should be used to determine states' obligations to mitigate climate change. Second, best available science dictates that to prevent further climate change and restore climate stability, states must urgently work to reduce the current concentration of carbon dioxide in our atmosphere to a level that is safe for humanity. That level is 350 parts per million, or ppm, and no higher. Third, reducing the concentration of carbon dioxide to 350 parts per million requires states to phase out fossil fuels no later than 2050, striving to do so by 2035. This phase out is necessary to protect children, and it is feasible. Your Honors, states have long known that the concentration of greenhouse gases matters. As early as 1992, they agreed that the ultimate objective of the UN FCCC would be, quote, to achieve stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system, end quote. Carbon dioxide is the most important of the greenhouse gases because CO2 pollution from fossil fuels is the primary driver of climate change. Your Honors, since 2008, separate teams of leading international scientists across many disciplines have identified the target for atmospheric CO2 that would stabilize our climate system. Peer-reviewed study after study found that CO2 should not exceed 350 ppm. This target not only provides climate stability, it is measurable and enforceable by courts. This limit is not controversial. No scientific body, including the IPCC, has ever indicated that concentrations above 350 parts per million are safe. However, the IPCC has unequivocally found that 1.5 degree target that states are currently aspiring to heat the planet to is not considered safe. And they went on to underscore that every ton of CO2 emitted amplifies danger. Despite these clear scientific findings, states continue to push the 1.5 degree target as the goal that humanity should aim for. The reason most often cited to justify 1.5 is that it will avoid the most irreversible and catastrophic harms. Yet, as Kalalapa explained, unprecedented storms sweep away children's homes, and fires stifle our children's ability to breathe. I ask, is that not irreversible and catastrophic? Amici respectfully submit that states should immediately align their mitigation efforts with best available science, and that is to reduce CO2 from today's concentration of over 420 parts per million to 350. Achieving this will prevent and mitigate the well-established direct impacts of climate change on children's health and well-being. Thank you, Your Honors. I now pass the floor back to Ms. Winter.
Your Honors, you just heard from Ms. Matheson why it is crucial to obligate states to meet a science-based standard and phase out all fossil fuels. It really is a life or death. Our rights are already being violated. Government entities producing and promoting excessive greenhouse gas emissions have already led to 1.2 to 1.3 degrees of global warming. With today's level of heating, we have lost our ability to practice our lifeways. We have lost our cultural heritage, our homes, our livelihoods, and our health. For some of us, we have lost our lives. As Ms. Matheson stated, best available science confirms what we already know. The Paris Agreement target of 1.5 degrees is too hot to protect our human rights. Instead, governments must bring down atmospheric CO2 to 350 ppm, and to do so, they must entirely phase out fossil fuels. If we don't do this now, there isn't going to be a future for any of us. Mahalo piha, thank you from the bottom of my heart.
Thank you very much. Seguidamente, le doy la...
We will now hear from the Center for International Environmental Law, NYU Climate Law Accelerator, Greenpeace International, Open Society Justice Initiative, and Union of Concerned Scientists. You have the floor.
Madam President, honorable members of the court, my name is Dr. Carly Phillips, and I'm a research scientist with the Union of Concerned Scientists, speaking to the science on behalf of our delegation. The science is clear and the evidence overwhelming. Climate change is already disrupting life across the Americas. People in vulnerable situations are experiencing the brunt of its impacts, and a relatively small number of business enterprises, chiefly in the fossil fuel and agro-industrial sectors, are driving this crisis, both through their contributions to the physical processes that warm our planet and through their manipulation of climate science, public discourse, and political systems. Without immediate action by governments and these same enterprises, climate-driven damages and irreversible losses will reverberate for generations to come. Human activity, primarily the production and use of fossil fuels and deforestation, has increased atmospheric greenhouse gas concentrations beyond levels ever before seen in human history. Research led by Rick Heady has shown that nearly 2/3 of global industrial carbon dioxide and methane since 1751 can be traced to just 90 entities, the carbon majors, including ExxonMobil, Chevron, and Pemex, which are based in the Americas. Similarly, more than 80% of deforestation and its associated emissions result from agro-industry, including the production of beef, soy, and palm oil, commodities dominated by a small number of large multinational companies. Such rapid changes to the atmosphere and the resultant 1.1 degrees of warming have already triggered a cascade of impacts, from widespread coral bleaching to severe drought. No amount of warming is safe. At current levels of warming, sea levels will continue to rise for centuries to millennia, but the speed of greenhouse gas reductions will determine its extent. Attribution science allows us to link specific events like heat waves and floods to climate change, and in turn, to link climate change to specific sources of emissions. Research in this field can now show, for example, that climate change doubled the likelihood of extreme rainfall and flooding in Peru in 2017, which led to 67 deaths and thousands of evacuations. Source attribution research further shows that more than 40% of the increase in global mean surface temperature and roughly 1/3 of sea level rise since 1880 can be traced to emissions from the carbon majors. And our own research has found that more than 7 million hectares of the area burned in forest fires in Western North America since 1986 is attributable to emissions from these same 90 entities. But beyond these physical contributions, social science research has revealed how business enterprises understood the root causes and future consequences of climate change, denied and cast doubt on the mounting evidence, deceived the public about the risks, and obstructed action for decades. In 1965, Frank Ickard, then president of the influential trade group, the American Petroleum Institute, delivered an address to fossil fuel industry leaders about the risks of carbon dioxide pollution, warning, "There is still time to save the world's peoples from the catastrophic consequences of pollution, but time is running out." His statement underscores how for more than 60 years, the fossil fuel industry has been aware of the risks that their products pose to humanity. By the 1970s and 80s, the industry's own scientists correctly predicted the trajectory of global warming and used this knowledge to reduce physical risks to their operations and profits. Publicly, however, and to this day, The fossil fuel industry has greatly expanded production of their climate-destructive products and has worked to ensure society's dependence through a concerted campaign to promote skepticism of climate science, obstruct regulation, and spread disinformation. As the research makes clear, the conduct of business enterprises is already eroding the foundations of life in the Americas. Climate impacts will only worsen with every 1/10 of a degree of warming, and decisions made this decade will determine global temperature trajectories for generations. 2023 was the hottest year ever recorded, and with each additional ton of greenhouse gas added to the atmosphere, we will keep breaking records. The human rights impacts of climate change will only escalate, and the mounting risks will become increasingly complex and difficult to manage. Thank you for your attention. I respectfully request that the court give the floor to my colleague, who will address the legal obligations that follow.
Honorable Inter-American Court of Human Rights, distinguished members of the audience. My name is Maria Alejandra Sera. I'm a lawyer with Greenpeace International, specializing in human rights and climate change. Honorable judges, by eroding the basis of the existence of humanity, fossil fuel companies and agri-industry are impeding the full enjoyment of all rights enshrined in the American Convention. These companies have a name and a last name, and they operate in virtual impunity in the face of their significant contribution to climate change. They may be based in the global north, such as ExxonMobil and Chevron, or in Latin America, such as JBS, Petróleos de Venezuela, Pemex, and Petrobras. These last three ones are actually SOEs. In the case of La Oroya versus Peru's ruling, this court said that the preservation of an environment that is viable for human life calls for the prohibition of conducts that may cause serious, extensive, and long-lasting and irreversible damage to the environment. By significantly contributing to climate change through their conduct, these fossil fuel companies and agri-industry are causing exactly that: serious, extensive, long-lasting and irreversible damage to the environment and as a consequence to human rights. This is happening at 1.1 degrees of global warming above pre-industrial levels. Going over the threshold of 1.5 degrees would bring devastating consequences for millions of people and would undo the last 50 years of progress in terms of development, health, and poverty reduction that has been said in so many words by the Inter-American Commission of Human Rights. As global warming increases, so do systemic inequalities, especially for persons and communities living in vulnerable situations. Let there be no doubt the existence of such structural inequalities and vulnerabilities to climate change are a direct consequence of the colonial legacy of exploitation and extractivism led by global north companies that still exists today. It's a legacy built on a system of racial and social hierarchies that still benefits companies by not regulating them effectively and facilitating corporate impunity. In order to meet the obligations in human rights, states must put an end to business conducts that cause climate change, as my colleague said, and in light of the principle of the polluter pays, states must guarantee full reparation for the damage that has already been caused. Allowing companies to continue to operate as they do today may lead us to cross the global threshold of 1.5 degrees, even by the end of this decade. Honorable Court, this cannot be allowed. Large fossil fuel companies and agri-industry companies are some of the major financial entities in the world. Some of them are even as powerful or more powerful financially than states. Their financial power and their influence on climate policies means that state action itself alone cannot prevent or repair fully the damage caused by the business conduct based on the UN's principles on companies and human rights. This responsibility of companies has been respected and reinforced by legislatures, national institutions, and the judiciaries, including rulings by this Honorable Court and the High Courts of Colombia, Peru, and Canada. Honorable Court is essential to harmonize the interpretation of the regional courts, of the region's courts, to the obligations and the duties of these companies when it comes to human rights, and that they're also under the obligation to respect human rights. Excellencies, it's not possible to guarantee effective enjoyment of the right to a healthy environment or any other human right for that matter without a stable climate. Based on science, in order to guarantee that the climate is stable and to prevent further violations of human rights, states and companies may have ambitious goals to reduce greenhouse gas emissions, not through speculative, unproven technologies, but by stopping the expansion, production, sale, and combustion of and burning of fossil fuels, and stopping the destruction of natural carbon sinks. And they must abstain from capturing and unduly influencing public policy, including antics to prevent climate action. So the window of opportunity that we have to guarantee climate stability is closing. Through this advisory opinion, this Honorable Board has the opportunity to put an end to the legacy of impunity of these large companies and stop the destructive practices that may lead us to cross that threshold of 1.5 degrees. The very existence of humankind is at stake. It is time to look into the future and create a path to protect human rights as has been promoted by this court for the last 4 decades.
Thank you for your presentation. I will now recognize Mr. Jorge Calderon Gamboa. Thank you, Madam President. Honorable judges of the Inter-American Court of Human Rights, my name is Jorge Calderon, and it is an honor to come before you on my own behalf and also on behalf of the Co-Evolution Foundation to discuss 5 crucial visions for a comprehensive analysis of the climate emergency based on the legal framework available to this court, which stands out from other international courts that are also studying the same subject. In my written submission, I addressed 5 key perspectives. First of all, economic, social, cultural, and environmental rights, ESCREs. Second, rights to nature. 3, gender. 4, individual rights. And 5, climate justice. Given the time constraints, I will focus on only 3 of these. Number 1. The perspective of the ESCREs. This request for an advisory opinion does not make specific reference to ESCRs or to the discussions given in Article 26 of the Convention concerning the environment as an autonomous right. However, this framework is extremely important for this issue. In Advisory Opinion 23, the right to a healthy environment was based on the integrated and sustainable development given in Articles 30 and 40 of the OAS Charter. But in order to address the climate emergency, we also need to consider Articles 34 to 38 of the Charter in order to interpret Article 26. These provisions provide guidelines on cooperation among states in areas such as integrated development and participation by the people in this development. They also address goals associated with agriculture, health, food supply, housing, and urban conditions. They establish the responsibility to avoid adopting policies that could be detrimental to other states, regulation of transnational companies, and the exchange of scientific and technological know-how. Each of these provisions can be coordinated well in order to receive more information on the specific duties discussed in the field of climate as lex specialis, and expressing obligations associated with mitigation, adaptation, resilience, and shared but differentiated responsibilities, as well as the system of loss and damage. The court can also, at this time, set specific obligations for ESCRs on the subject. First of all, progressive obligations for updating policies to prevent, guarantee, and non-regressiveness in the case of this emergency by setting specific progress indicators. There are also immediate obligations that need to be updated in the face of clear non-compliance with environmental rights associated with access to health, suitable housing, health, food supply, and safe drinking water, or situations of emergency such as natural disasters, droughts, or climate displacement, where the states must take suitable action, deliberate action, specific and action free of discrimination. Services, whether or not they are given, must be evaluated in terms of quality, affordability, availability, and acceptability applicable to the SCRs. So there's no question that the approach to this crisis must be framed by the ESCRs. Number 2, the ecosystem perspective and rights of nature. With this perspective, the court will have the opportunity to move ahead in its considerations concerning an ecosystem approach to the crisis claim, not just anthropocentric. This request for an advisory opinion makes specific reference to the impact on nature. We must recall that in Advisory Opinion 23, the court has already established the intrinsic value of nature in the content of the right to a safe environment, lending its own dimension of protection, and explicitly in paragraph 62, it set forth the region's trend toward recognition of the rights of nature. To date, in more than 30 countries, including countries in the Americas, the rights of nature have been promoted and recognized legally, internationally, in the World Biodiversity Framework of Kunming-Montreal, endorsed this approach as an integral part of implementing the Biodiversity Convention. The UN Harmony with Nature program, for whom I have served as an independent expert, has been promoting recognition and implementation of this right worldwide before the General Assembly of the UN, and this has led to more than a dozen UN resolutions on the subject. The rights of nature arise from the recognition that all living beings and ecosystems have a critical role to play in the planetary balance and merit protection because of their intrinsic value and not just because of their usefulness for humankind. These rights include the right to exist, for nature to exist, to carry out its functions and to evolve, as well as to regenerate and restore itself. This legal recognition also entails protection for key ecosystems that play an essential role in climate regulation, such as forests, oceans, and other natural habitats that serve as carbon sinks and play an essential role in climate stability. All this contributes directly to mitigating climate change. This new paradigm is particularly important for standing up to the climate crisis, considering the planet as a living, interconnected organism without borders. If we do this, we will be able to determine state obligations and multilateral obligations from an ecosystem perspective, and entails citizen participation in protection of nature through such mechanisms as guards, custodians, and independent scientific committees. Ignoring this perspective would be a serious setback from the progress already achieved by this court and worldwide. Technically, we suggest that this perspective be addressed by means of an evolutionary interpretation of Article 26 of the Convention, as was done in Advisory Opinion 23, when it was included as a dimension of the environment. However, we propose that the court go even further by giving autonomous recognition of nature as a rights holder, which would lead to the complementary category of the ESCRNs and for nature, following the precedent of including the E for environmental in the ESCRs. 3, the perspective of individual rights. The climate emergency is a problem that affects the entire human race. The problem has been generated primarily by the large anthropogenic, governmental, and corporative emitters. However, it also contributes, but also every individual contributes significantly significantly depending on our own habits of consumption and lifestyles. In order to achieve real and sustainable solutions, everyone needs to be involved by means of key daily activities. It is therefore essential to activate mechanisms for individual duties that are provided in the basic human rights treaties, such as the American Declaration in its preamble and in Chapter 2, as well as the Universal Declaration in Article 29. However, it is Article 32.1 of the Convention that determines the correlation between rights and duties and says every person has duties to the family, to the community, and to humankind. This is a unique opportunity for everyone, all of us as individuals, to take on concrete actions to mitigate, offset, adapt, and strengthen faced with climate change as a joint solution. We propose such individual activities as encouraging efficient use of energy, regulating sustainable transportation and telework, education on responsible consumption, requirements for recycling, reusing, and waste management, taking part in ecosystem conservation, preparing ourselves for emergencies, and applying restrictions on the use of polluting products. People need to recognize their own footprint, minimize it, and offset it, but using a coordinated, comprehensive system. Many countries have had military service or obligatory civilian service in order to prevent crises or emergencies. In the same way, a universal ecological service could be implemented to provide training and assistance in facing this crisis. This individual perspective fits within the convention, and is relevant to consider it in an advisory opinion, which does not set responsibilities. Instead, it's the states that must regulate these activities. Individuals, in turn, are responsible for complying with them in order to contribute in this emergency situation for the community, the planet, and future generations. Finally, our written submission in my written submission, I discussed the need to implement the gender perspective, recognizing the differentiated impact on women and girls because of the phenomenon of the feminization of poverty. We also propose a perspective of climate justice, in which the countries would adopt means of active standing for the courts to take on cases of this kind, using such ideas as diffuse interest or damage by proximity, as well as just as comprehensive reparation considers a climate perspective in harmony with the system of loss and damage. In conclusion, these 5 essential perspectives have an essential interpretational convention-based anchoring in order to provide an approach and a comprehensive solution to the emergency. We trust that the court will seize this historic opportunity to provide a fundamental contribution for the human race.
Thank you, Mr. Calderon Gamboa, for your submission. Before we start with the questions, the court wishes to thank the direct testimony of the teacher, the young women that came to speak on the impact of climate change on their lives and the lives of other children and adolescents. And now I wish to ask Judge Perez Goldberg if she has questions. Yes, I do. Please proceed. Thank you. Based on the perspective that we've heard this morning, I'd like to return to an aspect that we heard from Jorge Calderon, which is a perspective that is missing from all this discussion, which is individual action. I think it's important to use the space to refer to this. We have heard that Article 31.2 of the Convention mentions the individual duties that we all can employ to contribute to the larger cause. So with that in mind, I would like to ask those who have spoken how you believe we can delve deeper along those lines, so how each and every one of us could also contribute For example, by changing our consumption patterns, using transport differently, and particularly asking the young people we have here today, and echoing the words of Madam President, we believe it is greatly relevant to have their perspective. How can we collaborate along the way? Of course, the obligations are of the states, and our obligation is also to determine how states have to comply with their obligations. But there's no doubt that individual action is also of great importance. And just to highlight one aspect, recently the United Nations launched an alliance for sustainable fashion, and there's a dimension there, which is not minor, regarding the use of water by the fashion industry. And again, the consumer patterns and fast fashion. So just an idea, but I would love to hear from you, whoever has an idea regarding this. Thank you.
Thank you, Judge Perez Goldberg, for this very interesting question. And I speak often to children, and they also usually ask that question, what can we do? And I think it's a pertinent question, but we have to be mindful that climate change is a very complex issue. Making the right choices here, and you mentioned the fashion sector, clothes, production patterns, consumption pattern, is very complex. And making the right choices is very difficult. It demands a lot of information and basing choices on information. And I think for that reason, it is so important that states intervene, that they put in place the right legal framework and regulations that help individuals making the right choices, because it also has to be on a level playing field, that not I do something, my neighbor doesn't do something, but that the level playing field is there that upscales individual action to the level that is necessary. Thank you.
Gracias, Su Señoría.
Thank you, Your Honor. Based on the climate activism we have done in Colombia, and I'm talking about one of the organizations of my amigos, there's something very important to close the gap between what citizens can do and what companies and states can do. First of all, education. Our work in our territory has shown us that youth need many more areas and spaces to understand what a climate crisis is, to develop education on the impact of climate change, on the climate crisis. Our education system does not contemplate anything on climate change and climate crisis, and then these citizens are going to be working without having the right context of the environment we're living in, and without understanding how much their actions and omissions may have an effect on others. And secondly, participating in environmental matters, youth participation. The Escazú Agreement, an essential document for our region, it also shows how to participate in all instances, all population groups. It's very important to ensure, to close gaps, that we participate and to have more citizen action. We have realized that when our citizens are informed, it's much easier for them to participate, because you feel you are capable of understanding what is being dealt with and what people are talking about and having your own position. So from an activism posture, we need education and participation. And it cannot be limited to just having a space where people can talk. We also must have instruments to provide them and help them qualify their participation. So regardless of the role of youth, whether they are activists or not, that they know that all their actions and omissions do have an impact on the environment. Thank you. Thank you. Go ahead, please.
Thank you, Your Honor. I think to your question, individual choices are undoubtedly important, but focusing solely on those, I think, obscures. Sorry, I'm hearing myself. Obscures the systemic nature of the problem. I also think it's important to note that BP popularized the idea of a carbon footprint in the early 2000s as part of their rebranding campaign to Beyond Petroleum. They published the first carbon footprint calculator as part of that effort. And so I think in addition to considering individual choices around consumption, it's also important to think about the context in which those choices are occurring, especially for those youth who are born into a fossil fuel dependent system whose choices are limited if they are to exist in the world. So to tie that all together, I think that yes, individual consumption choices are important, but I think it's also important to look at the context of those choices, as well as the limitations that disinformation, manipulation of our public systems and our public discourse by this very powerful industry have played into the context in which those decisions occur. Thank you.
Muchísimas gracias.
Thank you so much. I'd like to ask Attorney Calderon in this same context, and on the basis, as we've heard from all of you, that we have to use the best available scientific evidence. The IPCC has highlighted the importance of individual action as a complementary mechanism to state action to ensure we achieve the goal of global reduction of emissions. I just gave the example of the fashion industry, but there's others. You've referred to telework, the use of transport. So if you could please give us some more information under this article that the court has not interpreted as much in its jurisprudence, both with advisory opinions and contentious cases. Thank you, Madam Judge. We do see that the foundational treaties, the Universal Declaration, the American Declaration, and the Convention itself, starting in the 40s and 60s, did contemplate that human rights were also complemented by duties, and that was a very important step universally and legally. However, due to the circumstances in our region and in the world, we tend to focus on obligations of the states, and that is perfectly fine. My proposal is not trying or seeking to avoid the responsibility of states, and that's why we have also presented the other perspectives. But just as we evolved to consider responsibilities and liabilities of companies as legal persons, or based on the ICJ's, the individual responsibility, human rights also have that perspective of individual duties. We all understand, and there's consensus, that we're living in an emergency. It is no longer the time for only states to take general action. We are all involved, especially if, of course, our habits have an implication in how we consume goods from these companies that produce fuel, fashion, etc. Yesterday we had a representative from UN Habitat, and we heard others refer to the right to the city, and how to have the right to the city we should have access to sustainable public transport, but also options to work remotely or for telework to happen. This can substantially contribute to reducing emissions in transport. So recently we all lived through the crisis of the pandemic, and somehow, in one way or another, each one of us had to participate, whether working remotely, whether using our face masks, to ensure that this public health problem could be solved. So I think this is one example, again, where we have the article already, there's the provisions there, and there's consensus, and so we can all do our part to contribute to the solution. Thank you. Thank you so much. No more questions. Thank you.
Thank you, Judge Perez Goldberg. Judge Veronica Gomez, do you have any questions? Yes, ma'am. First of all, I'd like to acknowledge the testimony.
Giovanna Hochstialik, Laura Serna, Ms. Winter, thank you very much for the testimonies. First question is to Christine Voit. You were very, very emphatic about positive obligations to implement adaptation and mitigation actions. We heard yesterday from different speakers about the fact that in many cases when we see international community getting together, it's more than anything a display of voluntary pledges. Also the process by which these targets are negotiated and fixed. So how do we get, or do you think we are in the realm of voluntary pledges, and how do we move to your scenario where you're saying we need positive obligations that lead to actual implementation and also fixing certain targets? So, thank you.
Thank you very much, Judge Gomez. Very important question. I mentioned positive obligations in the context of the American Convention. States have positive obligations to protect human rights under the various articles of the American Convention, in addition to negative obligations as well. But the question is, what is the content of these obligations? What do states actually have to do in order to protect the various human rights against the impacts of climate change? And in this context, the pledges and the whole architecture of the Paris Agreement comes into play, and we already discussed that yesterday to a certain extent. And here I think it's important to understand how the Paris Agreement works. The communication of nationally determined contributions is an obligation. It's an obligation of procedural character. Parties have to do it every 5 years. The next time, next year. It's a very important year, 2025. And in these communications next year, parties have to be mindful that their NDCs will represent a progression compared to their current ones and will reflect their highest possible ambition. And the core question here is, what does these elements mean? And these are due diligence benchmarks for what parties need to do. It's not an obligation of result, but it's an obligation of conduct. Parties will progress from where they are currently, and we all know that current ambition is not sufficient.
Can I interrupt you for a second? Because yesterday it was argued that there was a lot of uncertainty about information. That sometimes there were different renditions of to what degree states had actually met the targets or not. It was argued that there were different sources sometimes the information was not really clear, and that even civil society organizations had to resort to judicial action to have access to clear information. So during this process, is the information also reliable? You said 2025, very, very important moment, and everybody had to bring their own figures.
Yes, two points here. On meeting the targets of the current NDCs, I guess that was the context within it was discussed, there is another important deadline, if I can call it like this, and that's the 31st of December this year. At the 31st of December this year, all parties to the Paris Agreement, for the first time ever, have to submit something that's called biannual transparency reports. And in these biannual transparency reports, they have to provide information on their progress in achieving and implementing their NDCs. We have not received that information yet because it's the first time that this deadline applies, but it's going to be also very important access to information on how parties are actually doing in implementing and achieving their NDCs. And this information will have to be provided every other year from now on, from 2024, 2026, and so forth. So this is important to what I mentioned, to understand these cycles in the Paris Agreement and how they work and how they help us, everyone, to understand what parties are doing, because information is absolutely crucial, as you said, and this gives everyone a very important tool to access to this information.
Thank you very much. I have another question for Samantha Durksen. Yes. You spoke about the right to future generations and intergenerational justice, and you quoted a recent decision of the Inter-American Court. And what else? How should we or other international courts develop the concept of right to future generations and intergenerational justice? In which direction should it be developed in connection with the climate crisis?
Thank you, Your Honor. The principle of intergenerational justice has been recognized in many different instruments, including the Rio Declaration, the UNFCCC. This court has recognized it. Numerous human rights bodies have recognized it. The Maastricht Principles have recognized it. So it's a well-established principle that is part not just of the American Convention, but of many other international agreements, and it's become a general principle of international law. I will also propose to you that in the La Roja case, this court has recently spoken about the importance of the protection of the environment as part of human rights, and providing a clean, stable environment without irreversible damage to future generations is part of that important protection of human rights that the concurring opinion of this court has put abundant evidence forward is a jus cogens norm, and intergenerational justice is a part of that.
Thank you. To Kelly Matheson, you said that mitigation standards are measurable and enforceable by courts. You were referring to the reduction of CO2 to safe levels, 300 ppm. So tell us how to make them enforceable. Isn't
I would love
we're
to.
here for?
I would love to, Your Honor. Okay, so since CO2 pollution is similar to air and water pollution, the first place to start is to look at the decision in the Lo Arroyo decision and take that framework and put that in place, but then add to it. So the first addition would be to require that states adopt the 350 parts per million as a binding target for mitigation to ensure that there is a concrete, measurable aspect to our deep, rapid, and sustained.
It's not established in any document. No international treaty.
350 is not established in any legal, well, it is established in legal court documents. It is not established in a legal treaty. So, for example, the Supreme Court of Hawaii stated that it was absolutely necessary to hit 350 parts per million to prevent the violation of fundamental rights. Secondly, the state of Montana recently in Held versus Montana held that the atmosphere was degraded at current levels, and that we needed to get back to 350 parts per million, and that we needed to do this based on science. So that could be instilled into your advisory opinion. And then I would also suggest that this court oblige the states to come up with a comprehensive plan that has mechanisms and the principles and the policies, etc. And then on top of it, have them do an accounting every year like we just discussed. And then the fourth aspect of that is to ensure access to justice. And access to justice is essential, of course, so that standard could be enforced. And Your Honor, if you would permit, Kala Lapa would love to answer the first question that was asked by the judge, and she didn't have an opportunity. At some point, would that be possible?
Can we finish?
Yes.
You want to do it now?
Yeah.
Whenever you like. If I can finish my round, and then we can go back to. Okay, I don't want to monopolize the time, so just to note that took note of the attribution science. Very good. Thank you for mentioning social sciences and all things. Thank you very much. And the last one is for Jorge Calderon. Thank you for bringing up the rights of nature. It's, for the moment, it's appeared fewer times than I would have expected it to show up. So thank you for developing that. You mentioned, because the issue with the rights of nature and the non-anthropocentric vision and ecosystemic obligations, thank you for the conceptualization. You mentioned the guardians. The issue is who represents nature at the end of the day. You want to sit nature on the table, but who speaks for nature? So can you say something about that, please?
Sí, gracias.
I apologize for asking in English. Thank you, Your Honor. Yes, indeed, comparative systems that recognize the rights of nature have agreed to have participatory representation systems. Some countries and some systems have considered having guardians of nature. They may be indigenous communities or that have represented the rivers, for example, in cases, or the system of guardians, or in Spain with the recognition of the lagoon of the Major River, a scientific community that may represent and be the guardian of that body. So you're saying it should be decided on a case-by-case basis, meaning that it wouldn't be a set representation. Right. Since this is happening organically in the countries, what we see is people come together to express interest in protecting those bodies. Through citizens' participation, different systems, ad hoc systems, have emerged. And who is there research being carried out as to who might be interested or not? I mean, who is going to represent nature in the comparative? I mean, we're talking about over 300 ppm. Let us be reminded that many countries recognize the rights of nature in their constitutions, so that has given active standing to groups that claim to represent a lake, a river, a forest, etc. So I think this has happened on a case-by-case basis, but of course calls for a comprehensive analysis to see what the best solutions are. But if we look at the comparative examples, they have been pretty positive. And legal systems through constitutional legislation or domestic legislation are based on court decisions have allowed this type of representation. Thank you. No further questions.
I'm sorry. You want to answer her question? Okay. Then wait. Go ahead.
Thank you.
Thank you.
De que la realidad.
Thank you, Madam President. I just wanted to emphasize the fact that it's case by case, and legitimacy depends on what the law says. The figure of a steward of nature, the guardian of nature, comes from the Ecuadorian constitution. What we see more mainstream now in a series of courts in the region recognizing are the ecosystem functions or roles and ecosystem cycles and how they guarantee human rights. The Supreme Court of Mexico has pioneered these aspects. In Costa Rica, we also have examples of how mangroves contribute to the right to water using the criterion standards from General Observation number 15 to give you an idea. And this goes along the same lines, the fact that although we may have compensation as a financial remedy or reparation, that should be additional to, and even under the priority of nature. Nature has the first priority to guarantee other rights. To measures such as restitution and other nature-based solutions, and we also have a standard for that. Now, go ahead, please. The answer we.
Thank you. We still have a pending answer to the last question.
This is in response to the first question asking about individual action. So with the case that I'm in, and in general, I believe that individual action is only possible through institutional action, which is clearly why we're all here. I think that I would like to emphasize, someone else had said that requiring education systems to inform citizens of the impacts of the climate crisis and the impacts they have as individual people is also quite necessary to have the solutions actually work. I can give an example in terms of my case. We got asked by the opposing lawyers what we were doing as individuals, and keep in mind this is children. These are children from, our youngest plaintiff is 9 years old, and I at the time was 19. We were asked what we were doing as individuals to contribute to, or to not contribute to, the carbon emissions that we were referring to. We were asked about electric vehicles. My response was, how is it possible for any of us or our families to have electric vehicles if our system of the state of Hawaii and Department of Transportation hasn't put in place affordable ways for us to access electric vehicles, or affordable ways for us to access electrical vehicle charging systems the way that many other states in the US have. I think that is a really important aspect of it, is how can we encourage individual action to be taken by the individual citizens while also providing them with the means to do so. So in the case of electric vehicles, it'd be providing electric vehicle charging systems and such.
Madam President, could I ask that Giovanna also gets an opportunity to answer the first question?
Yes, briefly, please.
Thank you.
Thank you so much for the opportunity. I'll keep it very brief, but from my perspective of my home, there's something my father said to me that I like to say when I speak to other youths is, one of the most dangerous and one of the most deadly causes that affect our world is that we often tend to believe that somebody else is going to save it. We have to, with the youth, how we get the volunteerism is we need global volunteerism. We need everybody working together to make a change. And that ties into education that Laura had said. I'm a teacher, I have students, and when I spoke to them once about the rising tides on the Karanaj, they were shocked because they didn't realize, because they had gotten used to it. They go to the Karanaj and they see the water coming in and they're like, oh, this is an everyday normal occurrence. We need that education for people to understand and people to know that the time is now, because there is not going to be a time later.
Muchas gracias.
Thank you. Judge Veronica Gomez, have you finished your questions? Thank you. Judge Perez Manrique, do you have any questions? Yes, Madam President, I do. I would like to recognize the high level of this panel, the participation of young people in particular, which is so important. And it is important to see you involved in this whole matter of climate change. My first question is for the Center for International Environmental Law and all the rest of your partners. You made a very emphatic statement concerning specifically the responsibility of agro-industry and the oil companies in climate effects. Obviously, faced with, as we consider that statement, I would like to ask you if you could go into more depth as to what obligations should the states place on companies of this kind. You yourselves emphasized that even though they are in the north, nonetheless they are transnational and their impact is worldwide, so perhaps you could clarify that for me.
May it please the Court, Nikki Reich from the Center for International Environmental Law. Thank you, Your Honor, for this question, which is very important. I think our arguments are twofold here. In the face of the unequivocal science that indicates the overwhelming responsibility for the climate crisis that falls on the fossil fuel industry and agribusiness in particular, that the legal obligations on the states to effectively regulate the conduct of those enterprises encompasses not only regulation of their physical activities that cause emissions and climate destruction, but also their socio-political activities which impede the regulation of the destructive conduct and delay or deter climate action that is necessary to protect human rights. This court has said on many occasions, emphatically in its past advisory opinion and in La Arroya as well as other cases, that the duty to regulate encompasses taking measures that are capable of preventing that foreseeable harm caused by third parties and implementing them effectively, not only to ensure urgent action that can safeguard all human rights, but also to hold those actors accountable. And so the duty to regulate encompasses addressing both physically destructive conduct, but also the socio-political activities, the obstruction and deception of regulation, and the activities that effectively impair access to justice. We have seen countless times that the fossil fuel industry and agribusiness and other large corporate actors, as was addressed yesterday, have captured policymaking and have used escalating tactics to prevent access to justice in the form of slap suits and other means, and that this use of deceptive tactics has impeded the ability to protect human rights and to take regulatory action. But our arguments are also address the responsibility of the state to ensure full and adequate reparation for the harms that are caused by this corporate destructive conduct, and that includes both procedural guarantees of access to justice, but full reparation, as this court has elaborated in its jurisprudence, encompasses not only compensation, but restitution and satisfaction, and a range of creative collective remedies and reparations for the harm that has ensued. Beyond that, we have, in our written submission, emphasized that in the current context, the duties and obligations are not only on the state to refrain from such destructive conduct and to regulate third parties, but for those third parties themselves to refrain from conduct that states and businesses have an obligation to refrain from conduct that causes and impairs human rights. I'm happy to elaborate further if Your Honor would like, or to turn it back to my colleague from Greenpeace to elaborate further. Did I answer your question, Your Honor?
You cited the case law of the Inter-American Court, which clearly makes reference to the case of La Arroya, I assume. But you yourselves also said that these are companies, multinational companies, whose action is worldwide, is global. So how can these principles that are set with concrete obligations by the states, how can they be applied to a party of this kind, a player whose actions, whose economic activities are worldwide?
If I may. Thank you, Your Honor. I think the critical feature of the duty to regulate is the extraterritorial reach of that duty. And this court has said very clearly that the obligation extends to all conduct that is subject to the jurisdiction and control of a state that has consequences that impair human rights, regardless of where those consequences occur. And so the conduct at issue here is not only in the home states of many companies registered in the global north, including in the North America within the region subject to the jurisdiction of this court, but elsewhere, and that the states have an opportunity and an obligation, in fact, to address when they have the ability to control the sources that lead to emissions that are generating human rights adverse human rights effects around the world, they have an obligation. This court has elucidated that in its own jurisprudence, but also it was very clearly articulated by the Committee on the Rights of the Child in Sachi, and that responsibility and that ability to control the sources, including the decision-making around corporate conduct that occurs overseas, extends to and encompasses an obligation and an ability to control those emissions. But as we have indicated, the responsibility on the part of companies headquartered in the global north and the ability of states in the global south to hold those companies accountable is also contingent upon removing the barriers to regulating and effectively holding those companies accountable, which include, as we've mentioned in our written pleadings, investor-state dispute settlement and investment protection, which represents a threat to states that seek to regulate and hold corporate actors, including those of the North, accountable. So it is also, we respectfully request this court also to address in its advisory opinion the removal of barriers that prevent and impede the state from exercising the full scope of its duties and obligations that can in fact reach that extraterritorial conduct and that can hold corporations to account for their operations and impacts globally.
Thank you for your answer. Unquestionably, this is a very complex matter because it is associated with the obligations that are included in investment agreements. Very often these obligations are contracts of accession that are signed by the states themselves. Thank you for your answer. In the case of our Children's Trust and your colleagues, in your submission, you discussed something that we had not yet addressed here. That is to say, the dilemmas involving the use of technologies to remove carbon or eliminate carbon, and that sometimes they themselves become critical areas for human rights. Could you talk more about that, please?
If I'm understanding correctly, Your Honor, we're talking about the technical feasibility of reducing CO2. Is that correct?
We're talking about you said that there are technologies for eliminating carbon and that they in themselves can be detrimental to human rights. I want you to discuss that, please.
In our brief, we primarily discuss the technologies that are helpful to human rights. So, for example, in Annex F, let me start all over. I want to draw your attention to Annex F because that links to 145 roadmaps that were developed by energy scientists out of Stanford University. They have created roadmaps for all of these countries, including most of the countries in the inter-American system, on how to decarbonize, defossilize by 2050 at the latest, but 80% by 2035. Dr. Jacobson, who was leading this effort, testified in the court in Held v. Montana and noted and underscored that these roadmaps are only one way that states can decarbonize. So the key here is that states have to get off of fossil. That they don't have a choice about. But they do have a choice about how they get off of the fossil. So the states will be able to make that. I also want to emphasize that in addition to being technically feasible, all of this pathway to 350, this pathway towards decarbonization, is highly economically beneficial, even to the states that are fossil dependent. It is also supports energy security, and it also supports climate justice. Does that answer your question? In our brief, we didn't talk about carbon capture and storage, which is dangerous.
Good, thank you. Thank you. I have a question for the Human Rights and Environment Center, FACE. You made a very interesting comment about requirements for suitable justice in these matters. And then you talked about the need for structural change in order to overcome the emergency situation of the climate. Perhaps you could go into more depth as to what would be the qualities of this type of justice, efficient and suitable justice on climate. What would it look like? And what structural changes would be needed in order to overcome the problem of emissions?
Thank you, Your Honor. As we have emphasized in our amicus brief, what justice requires is both focusing on the near term as well as on the long term. So that means both focusing on cutting CO2 as well as cutting SLCP, short-lived climate pollutants, and protecting natural carbon sinks. That is absolutely critical. If we only focus on the long run, then we may be triggering tipping points that cause irreversible damage. So that, first of all, is what is absolutely crucial for achieving climate justice. And then in terms of the concrete structural changes, we have in our section 4D, I believe, set out concrete measures that we think will achieve this goal, including a moratorium on new fossil fuel projects and expansions of existing fossil projects, a moratorium on deforestation projects, and many other measures that we have included in that section.
Thank you. I would like now to address the two young people who have taken part in this hearing. If you could tell us what you hope, what do you expect or hope from this court? What do you hope that this court can do by means of the advisory opinion that we will be issuing on the climate emergency?
Thank you for the question. I believe what the youth are expecting the most is that we want an enforceable right to a life-sustaining climate system. And as a part of that, we also need a systematically durable, or multiple systematically durable solutions towards the climate crisis. Yeah, short answer.
I too have a short answer. As she was saying, the youth want a right to be able to survive the next 50, 100 years. With the way that the world is going, it's seeming less and less likely. All we're hoping is that there are stuff put in place to prevent further damage to our ecosystems and our homes and our lands and our livelihoods.
Thank you for that question. I think there are a number of things we hope for as young people in our briefs. For example, the states know that there's a climate crisis. The states have seen the figures, but they have taken very few actions or insufficient actions. In a region as unequal as Latin America, it's unquestionable that many gaps need to be narrowed. Not only do we have the challenge of facing the climate crisis, but we also need to be narrowing all of the fundamental problems we face. We hope that the decision by this court would recognize these inequalities and would also recognize that the actions of young people are important, that it's not just give us a chance to talk when you ask us what we think or you ask us how it looks to us, but also we want to be part of processes in action. And above all, we would hope that the position taken by the court, which we know is limited by the things the states want and can do, but it would be play an essential role so that we as a region can play a bigger role on the climate agenda. And it wouldn't be just a decision, a statement that recognizes important things and sets guidelines for the states, but that for the population, and as the first judge asked, for individual citizens who may not know that it's what's happening here, would easily be able to understand what the court said and that they can be part of the process. Thank you. Thank you very much for your answers. I have no further questions, Madam President.
Thank you, Judge Perez Manrique. Judge Eduardo Ferrer MacGregor, do you have questions? Yes. Thank you. Coming back to the voice, my colleague, Judge Perez Manrique, just gave you the opportunity to speak your opinions. I'd like to ask the young women from another perspective. If future generations were to see the hearing we are holding today and could talk, if you could talk to the future generations, what would you like them to hear? The young people, the young women of future generations.
Opportunity to speak. To start off, I would like to say, if I were to be able to speak to the future generations, is that there is still hope. A lot of people think that the world is hopeless, that there is no hope of a sustainable future, but there is hope as long as we keep trying and as long as we are given the chances to have our voices heard and our opinions heard and our ideas taken into consideration. There is hope that we can fix the world and make it sustainable for the future generations.
Yes, I completely agree. If I could talk to the future generations, I would tell them that there are people fighting for them and that we are fighting for them and that their lives matter and their rights matter. Very similar to what they were saying, in my culture, as an Indigenous person, a huge part of our culture is intergenerational connection. As an Indigenous person, my kupuna, my ancestors, fought very hard for me to have a right to exist in my land. Obviously, with colonization, that was a very difficult, traumatic history. I would like to put out there that as an Indigenous person of today, I think this court should pay attention to Indigenous-based solutions. Indigenous people have existed for a very long time and have taken care of our ecosystems for a very long time. I like to talk about decolonizing climate solutions and using Indigenous-based knowledge with Western science-backed solutions is a huge, really important aspect that I think the court should take into account.
To add to our voices and not repeat, I would say that the coming generations will certainly have more tools based on what we do today, on the decisions made in areas like these today. And these tools should all help guide us in acknowledging the importance that we are individuals that should not consider ourselves outside of the ecosystem. We are part of the ecosystem. We should work in harmony and in collaboration with it and others so that we may survive and sustain ourselves within the ecosystem. So the call is to remember that what you do and what you don't do will always matter. And for future generations, we hope they will not have to take on disproportionate burdens because of the climate crisis. But even if they do, that they will have the tools to survive. Thank you. Thank you. It's very important to hear your voice. Thank you. And to the International Union for Conservation of Nature, you've told us we have a difficult or a challenging task, a problematic task, but not necessarily difficult as such. And you also say that in Dubai, 195 countries have already set out a roadmap, and that the roadmap should take us to 2050 carbon neutrality. So the question is, what are the obstacles? What obstacles exist? What barriers do we have to get to that goal, to follow that roadmap that the states themselves have set out? Yes, that's the first question. It's an important question, but not difficult to answer.
The decision from Dubai is actually very interesting, a very important one, because it's not just a decision, it's something that now needs to be reflected in the NDCs to be submitted next year. So there is a direct link between what was decided last year in Dubai and what needs now to be broken down to domestic context, but need to be reflected in this next round of NDCs. So that's the first very important element. So we need to see what comes out from states' NDCs next year to see whether it is well aligned with all these elements that are in that decision. It's much more than just the pathways to carbon neutrality. It's also transitioning away from fossil fuels, phasing out of insufficient fossil fuel subsidies, phasing down of unabated coal, and so on. It's so many detail that now is put to parties to reflect and include in their NDCs. Now, these are all very difficult choices for states to make. Some of them may not be choices that the public in general may want to see. So having a backup, having the support by the international community that points to the necessity of implementing these actions domestically may also give a backup to decision makers to take the right choices domestically. I hope that answers your question.
Yo quisiera agregar.
If I may, I'd like to add something specifically about our region. We have to recognize that the effects of climate change and climate goals have the possibility of hindering the right to development and even the SDGs that we have and even the development goals we have in the OAS Charter. So it takes, it can say something, but actually doing it is different. So states have committed to mitigating and reducing GHG emissions, to adapt because we don't have time, as we've heard our young people say, to create the enabling conditions that will allow development, because, again, we are the most unequal region in the world. And if we don't have jobs, we can't have environment. So, again, it's choices, very difficult choices, as we heard from Dr. Voit, that are reflected in the inventories, in the NDCs. But, again, it's a choice. It's a choice we have to make, and another important obstacle is precisely sovereignty of states. Well, I take note of the important date, December 31st of this year. We take note of 2025. But this court has to make a decision probably this year. I think time is running fast. So, as our Children's Trust told us, the Paris Agreement is insufficient. Article 21A of the Paris Agreement, if I understood correctly, is already incompatible with the best available science, and that other courts in the world are that have already taken action. We've heard that there are cases in Hawaii, the state of Montana, and they're not referring to that 1.5 goal, but identifying the 350 ppm limit and the energy imbalance as a point of reference to protect rights. So the question I'd like to have answered emphatically and with greater certainty, in light of the best science available at this time, 23rd, 24th, I'm not sure what day, 24th of April, 23rd of April, 2024. No, 24. So 24th of April, I'm talking to the future generations. So as of today, what is the best science available? We know that there's the expert committee, but then we are hearing that next year might be renewed, there will be a new constitution. So as of today, what is the best available science? And it may seem this is the guiding parameter. Thank you very much, Judge McGregor. It's no secret, and this has actually been discussed. We heard that yesterday in yesterday's sessions, that as of today, the best available science is from the Intergovernmental Panel on Climate Change from the UN. That's unquestionable. But I believe that beyond an advisory opinion, if the Honorable Court has to deliberate on contentious cases, having criteria on what is that best available science is essential for them. And there we would have them consider standards such as the Dauber standards and the commonly accepted principle is having peer review, being able to trust the information, that there's reliability of scientific information in the IUCN. We have scientist groups, the Commission on Species, Ecosystems, that prepares our red list, so we follow scientific processes throughout. So when you have any questions, a specific question on a contentious case, those would be criteria to follow, and they have been developed by jurisprudence in the Inter-American system as well. So the court should consider these too.
One of the problems is that the IPCC hasn't been asked the question about what is going to create climate stability. The IPCC in 1992 did have 350 parts per million in its initial pathways that it was going to evaluate. But it left 350 parts per million out in 1992 because we had already crossed it, ironically, in 1998, the year that the IPCC was formed. So particularly as of 2015, the IPCC has been asked the question, what's the difference in the impacts? They haven't been asked, how do we prevent the impacts? And the IPCC hasn't had a chance to give us the answer on that. So scientists have. And scientists have told us, starting in 2008, that level that we needed to hit was 350 parts per million. That has been echoed again and again. And if you look back historically, the study of the concentration of CO2 in the atmosphere has been going on for 100 years, more than 100 years. So so we know what is safe. We just need the IPCC to be asked the question.
Thank you. I just want to push back or be a little bit careful about dismissing the Paris Agreement and its temperature guardrails. It is very important, I think, to recognize that here we have a global science-based consensus with real legal implication. It's an international treaty, which matters also in our context, that sets that critical threshold. And it is something that was a red line for small island developing states when the agreement was negotiated. They needed to see 1.5 degrees in that particular article. They said there would not be an agreement without that particular mentioning. So it's very important to recognize the importance of that guardrail also in the context of most vulnerable states. And we must not forget that there is another temperature target or number mentioned in Article 2, which talks about well below 2 degrees. Now, in all our conversations yesterday and today, we focused only on 1.5 degrees. And I think that's a very important moving of the needle in a way, because 1.5 degrees is now globally recognized as being the guardrail that matters. Nobody's really talking about 2 degrees anymore, and I think that's also due to science. But talking about stabilization targets and the Framework Convention in its Article 2 sets out the ultimate objective to stabilize greenhouse gas concentrations in the atmosphere at the level. And that would prevent dangerous interference with the climate system. Now, it was never possible to specify where that level is, not in a concentration target under the Framework Convention. And for that reason, it was so important when in the Paris Agreement, states were finally able to define a temperature target. I think this is very important to take into account and build understanding of these legal implications based on that overall consensus. And I think it's also important to read out what it implies to keep with that target, because these are going to be very difficult choices to make, as we've already been talking about. Getting to global carbon neutrality in 2050 is an unprecedented task. This is something that humankind has never done before. It will require transformative changes across everything we do globally. And I think that in alone is worthwhile keeping that temperature goal or target or threshold or whatever we want to call it as a guiding light that informs our decisions. Thank you.
Your Honor, if I may add a few thoughts. Thank you so much. I think I agree with everything that's been said, and I think it's critically important. I think it's a really important question. I want to reiterate something that I said initially and add to it a little bit. I think it is important to keep in mind that the 1.5 degrees is not a target. It's a guardrail. It's not something that states must achieve and then throw up their hands and say, we're done. And so I want to emphasize that it's a guardrail. But it is a guardrail that's important to keep in mind for two main reasons. One, it is something that we can speak to in the short term. I think the goals of the 350 ppm are probably not achievable in the next few years, but we need to make sure that in the next few years, warming doesn't exceed the 1.5 guardrail. So I think it is critically important for that purpose to keep the guardrail in mind. The guardrail also is an overall temperature goal, so it doesn't just include CO2. It also speaks towards SLCP, short-lived climate pollutants, and the preservation of natural carbon sinks. So in that sense, it's more encompassive. And I think that for those two reasons, it is important to keep in mind, but it is not a target. Thank you.
With your permission, could I respond?
Bueno, nada más preguntarle porque
just to ask you, because I think we had interrupted you. You said that the IPCC has not been asked. What should we ask the IPCC? Because you said they haven't asked this of the IPCC.
We should ask states to ask the IPCC to determine what level will stabilize our climate system. And I want to recognize that when we go back to 1992, states agreed that we would use the concentration of greenhouse gases in Article 2 of the UNFCCC, not temperature. The answer that I would give about temperature will take too long, but I'm happy to provide a one-pager on why temperature is not a good enforceable measure. But to give you some bullet points, first, temperature is the symptom. It is not the cause of climate change. If I go to the doctor and my child has a fever, I can give the child medicine, it will control the fever, but until I take care of the cause, the child will not be healthy. Additionally, temperature varies all over the world. Temperature in the Arctic right now is already 2 to 3 degrees higher. In Barbados, we're about 1.1, so that begs the question of 1.5 for who? Third, the temperature average is a moving target. If you look at the 10-year average of NASA, GIS, NOAA, Berkeley, and Hadley, one is 1.1, one is 1.2, one is 1.3. Fourth, the IPCC uses a 20-year average to determine temperature. So yes, 2023 was over 1.5, but there's too much noise. We can't use just 1 year. They use a 20-year average. So we will not know for 10 years if we have passed that 1.5 target. And there are more reasons why temperature is not a good enforceable concrete target that I'm happy to provide to the court.
I will go ahead and, because I was going to ask, and you can answer as well. The Center for International Environmental Law and other associations. Judge Perez Manrique asked a question that I believe is very important, and some of the written submissions have mentioned it, which is false solutions or high-risk solutions. Carbon compensation, technologies based on hydrogen, carbon capture, geoengineering, also that could be even detrimental. And it's very important to the matter that you've brought up. So if possible, could you please expand?
Claro que sí.
I will begin, and then my colleague Carly will add to this from the science perspective. For us, it's important to highlight that 1.5 is a planet limit, and we've heard from colleagues, science is completely clear as to the fact that this is not a safe limit. However, it is a limit for the planet in the sense that if we go over that, it would lead to a high-risk climate zone or area where we are more likely to have tipping points, points of no return that would have more catastrophic consequences than we are living today, because as we've heard, current impacts are already irreversible. But going beyond or over that 1.5 would put us in a situation that is much worse, almost impossible to control. Therefore, it's very important to note that every year, dependence on fossil fuels should be phased out. The large oil companies and states, instead of focusing on policies to effectively reduce GHG gases, are increasing or continue to increase dependency on fossil fuels. They still provide licenses for the exploration of hydrocarbons. They still pass projects that include exploitation and production of fossil fuels even after 2050. And because of this, and also fossil fuel companies talk about technologies that don't exist as the solution to climate change. And the IPCC also says this, instead of focusing on what is necessary, which is reducing GHG emissions. These companies and states are allowing solutions to be posed that just don't exist at the time. And now I give the floor to Carly to explain from the scientific perspective. Thank you.
Thank you for the question, Your Honor. I think one of the things that's important to emphasize when thinking about technological solutions, I'm sorry, it's happening again. Okay. I'm learning. Is that when it comes to these solutions, they're often associated with overshoot, meaning that the temperature threshold is exceeded, but then certain technologies allow the temperature to be reduced over time, the technologies that you mentioned. But I think what's important to consider in that sense is that there are some impacts that will continue and be exacerbated regardless. And I think sea level rise is a great example. The oceans have absorbed over 90% of the heat that human-caused climate change has generated. And so as a result of that, there's thermal expansion, which is one of the drivers of sea level rise. And so even with overshoot and those reductions using those technologies, sea level rise is already baked in and locked into our system. So the relying on the technologies that you mentioned won't address all of the injustices that come as a result of climate change. And so keeping those two pieces in mind, I think, is really important when considering those technologies, and that they're only addressing one symptom and not necessarily the cause. Thank you.
With the court's permission, Nikki from the Center for International Environmental Law, I'd just like to add a couple points. And thank you very much for this question. I think, to be clear, some of the technologies, the techno fixes that are being proposed are not new technologies, but technologies that have existed for decades, as in the case of carbon capture and storage, that have been used by the fossil fuel industry, not for the reduction of its emissions and impacts on climate, but for expanding the production of oil through enhanced oil recovery. And in fact, what we've seen over decades of use is that these technologies have been proven to fail, whether through cost overruns or failure to meet the carbon capture targets that the projects themselves set. They have repeatedly been shown to fail, and yet the rhetoric remains the same. This is part of an effort to convince policymakers and the public that we can continue business as usual dependence on fossil fuels, somehow fix them rather than ditch them. But to come back to the preceding question, the science is very clear. There is not uncertainty regarding the causes of climate change. And that's why I believe this honorable court has a critical opportunity to make very clear that under human rights law, leaving aside the climate agreements and any specific temperature or particle targets, that the law is crystal clear that states have an obligation to take effective measures to curtail conduct that foreseeably infringes on human rights. And we know what that conduct is. The science is unequivocal. It is 80% of carbon dioxide emissions, or more in fact, are attributable to the fossil fuel industry, to the production and use of fossil fuels. And we heard extensively yesterday and this morning again about short-lived climate forcers. We heard about methane. So-called natural gas, a euphemism for methane, is one such short-lived pollutant, methane. And the single greatest way to urgently and in the near term reduce methane in the atmosphere is by reducing the production and use of fossil fuels. Because through leakage and through design, there is emission of methane throughout the life cycle of fossil fuel production and use. And I just wanted to underscore that. We see a lot of talk about other technologies, be they speculative direct air capture projects or geoengineering, that would place the burden on the future. These technologies are neither scalable and available in the present moment when it's most critical for preventing the irreversible harms and ongoing catastrophic impacts on human rights, nor are they without their own risks of grave human rights impacts. We know that they have collateral impacts through extensive input requirements, water and energy, and land grabs that they incentivize. So on that, Your Honor, I hope that addresses some of your questions, but I think it's critically important when we talk about, as was so emphatically and articulately presented, yesterday morning by the presentations on the part of Barbados and Vanuatu, among others, that when we talk about the Paris Agreement and climate agreements, we are very clear that nothing in those agreements displaces human rights law, and that this honorable court, in answering the question of what human rights law requires of states and arguably of corporations as well, that question derives first and foremost from human rights law that is longstanding. It pre-exists the UN Framework Convention on Climate Change and the Paris Agreement, and it succeeds them in the sense that it continues to apply with force alongside them. And clarifying what that law requires with specificity and urgency would be a great service not only throughout this region, but for the world as a whole. Thank you.
Be aware that we need removals of greenhouse gas emissions. We will not be able to get to net zero emissions or net negativity, which is the requirement thereafter, without reducing greenhouse gas emissions and at the same time increasing removals, because that is the meaning of net zero. It's the balance of emissions and removals. And that's also necessary in order to reduce concentrations in the atmosphere. We need to remove greenhouse gas emissions. That should not and must not replace mitigation action that is at scale, but it's something that we need to have in the back of our minds. Now, we've talked about technological solutions. And they all come with their own challenges, as we heard. But there are also natural solutions to removals. There is the power of nature. We can also remove by conserving forests, conserving mangroves, wetlands, peatlands, seagrass, meadows. There is a lot in nature that would help us to increase that potential to remove, in particular, carbon from the atmosphere. So nature-based solution is something that in particular the IUCN is promoting very strongly, but it's very important that also nature-based solutions need to come with strong social and environmental safeguard that do protect human rights against displacement, for example, but that can be complemented and be put into the framework that governs these nature-based solutions. Thank you.
En línea con lo que decía la doctora Voit, simplemente
Along the lines of Dr. Voit, just to refer to our written submissions where we expand on nature-based solutions and the definition adopted by the UN General Assembly on environment for these solutions. The nature-based solutions contribute and benefit both nature and people, considering that this court should be aware of the implications, the human rights implications that these technologies have with climate goal.
Your Honor. I think when thinking about nature-based solutions, it's important to think about a few things, specifically that nature-based solutions should not be an alternative, or should not be an excuse to not reduce fossil fuel use and to not continue with business as usual. I also think it's important to note that these nature-based solutions are also subject to the climate change and its impacts that we're seeing. For instance, our forests are burning. And so while it's important to protect and conserve those, I do not contest that. I think it's important to think about the way that these solutions are invariably impacted by the process that they are trying to address. Thank you.
No, al contrario, muchas gracias. Creo que
To the contrary, thank you very much. I've exceeded my time, so President, I won't ask anything of the rights of nature that has already been mentioned. Thank you. Thank you so much for all your answers.
Judge Mudrovich, do you have any questions?
Thank you, Madam President. I would just like to very especially thank, as my colleagues have done, to the three young women, the three young speakers we had from Grenada, Colombia, and Hawaii. It was very important to hear your words. Unfortunately, we do have to keep to a certain time, and we have to ensure that we keep it and to keep time for others. I have so many questions, but I just would like to ask one very brief questions, and I would also ask all our speakers to please be brief in your answers as well. And this question is to Jorge Calderon. Of course, I'd love to ask questions to all, but we don't have the time. You know about our jurisprudence, you know about the architecture of our court and our limits even. And you've brought up a very interesting argument covering 2 points that I found interesting. I would like to refer to some of the aspects you don't necessarily cover in your written arguments. Talking about the more creative forms of reparation and broader forms of legitimation and legitimacy. And this is not just for our inter-American system, but in national system. So if I may, could you expand on these? And please be brief. Thank you.
Yes. Thank you very much, Judge Mudrovich. We believe that climate justice cannot be materialized if in the countries in our region, there is no system for active standing and full reparation. So, active standing, as you've heard, there's the example of the Supreme Court of Mexico, where entities such as mangrove forests, coral reefs, or other natural entities have been represented by persons who, they represent a diffuse interest, an interest that does not necessarily lead to damage to that person. It's just an interest. They have an interest because these are environmental services. That's the definition that was brought, but it could be a different definition. But they come to court to demand reparations for a specific damage to the entity. Also, there's damage for proximity. What that means is that as long as there is an area of influence where the natural entity is being damaged and that person is close to it, and of course that will depend on the interpretation on a case-by-case basis, they may have active standing. And when it comes to reparations, it is no use for courts to simply collect information and ascertain that there has been damage if there is no full reparation, as is the case with the European Court, where 5,000 euros or a specific amount is ordered in reparations. The Inter-American system is reparation system is very broad, and guarantees of non-repetition is what may lead to structural changes in legislative terms and in practice as well. And as was the case with the case of Kalini Lokono versus Suriname, the measure of rehabilitation was used to observe the rehabilitation of the territory, even by the private company that was the one that polluted that area with the support of the state. So this types of measures is maybe crucial in implementing also the loss and damage system with measures of satisfaction, collective compensation, and non-repetition measures that can repair this system based on the system of loss and damage. As I hope I have.
Thank you. No more questions.
Thank you. So,
along the same lines, I would like you to tell us more specifically why it would be enough. It would not be enough to have the principle for establishing more effective solutions by the states in the case of the climate emergency. Please recognize how the right of nature, because why do you believe that it is not enough? Thank you, Madam President. I want to address the specific question as to why, first of all, it is not the principle pro natura is not enough. I think this is positive, but it's part of the whole scaffolding of the system of environmental rights or environmental law. The proposal of the rights of nature is more comprehensive if we take into account that we ourselves are part of nature. This perspective should not clash with environmental rights, but comparative experience worldwide, that is more than 30 countries all over the world have made progress in this regard, but we're seeing in their experience that you can have more comprehensive systems for protecting nature, even beyond environmental legal systems that partly require this active standing by means of damage, that is, specific damage is suffered. When entities are recognized as being subjects of law, we no longer need a person to have been hurt. It's enough for this entity to have these rights that we've described and is subject to protection. So we feel that these are approaches or perspectives that are complementary. Clearly, the discussion on active standing can be presented in both cases, but I do think that this could be the trend where the court would recognize these two visions as autonomous but complementary and provide a much broader perspective of climate per se and of human beings as members of nature. Thank you for that answer. I would also like to ask more questions, but our time is more than past for this first block of contributions. So we will take a break and be back at 11:45 to continue with the next part of the hearing. Thank you. Please rise. The court will leave this chamber. Good morning. We will now resume this public hearing following the order as established. According to the program before me, we will now recognize the representatives of the Center for Democratic and Environmental Rights. Please proceed. Madam President, ladies and gentlemen of the court, my name is Hugo Echeverria. I'm an external lawyer for the Center for Democratic and Environmental Rights, and it's an honor for me to be here in this hearing. We presented our submission, a written submission concerning the climate emergency, human rights, and the rights of nature. This is the subject I will be addressing this morning. First of all, I would like to note that we are extremely gratified at the ability that because of the fact that we are able to hear to talk about the rights of nature in a setting where the discussion focuses on human rights and the climate emergency. The CDER understands fully that this is a human rights case. Our hope is to submit insight on the rights of nature because this is a trend that is developing very quickly in the American states, in this part of the world. It is being led. This region is leading the trend in comparative law. We feel that this hearing and this topic that the court will be examining it marks a different scenario, a unique scenario, different from the approach being taken by other courts in the world for this very reason, because this is the region of the world where this new trend on the rights of nature is arising. This is not a new subject. The regulatory basis, the legal base, dates back to international public law in 1922, the Charter of Nature. This charter that has the same normative value as the Stockholm Declaration and the Rio Declaration, which were foundational documents for environmental law. The subject was reactivated in 2018 when Ecuador incorporated the rights of nature into its constitution. As time has gone by, we have seen new jurisprudential models evolving, such as was mentioned yesterday by Colombia, the case of the Trato River and et al. These cases are well known. Also the case of Bolivian legislation and more recently Panamanian law, and the very important discussion that took place in the Chilean Constitutional Congress. The most recent case of the Marañón River in Peru, and also what we are discussing right now is a constitutional amendment being proposed in Aruba. So we are seeing it. We are seeing the genesis of a new issue in the legal sphere, which is being promoted by our own countries. All of this has the same legal foundation, which is the World Charter for Nature. This is therefore an opportunity for us to move ahead with the legal foundation for these new rights, which was already mentioned by the court in OC 23 on human rights and the environment. We are discussing the possible integration or incorporation of the rights of nature into the legal analysis, the very complex legal analysis being done about the relationship between human rights and climate change, the climate emergency, as it was called by the Republic of Chile and the Republic of Colombia. We, from the CDER, feel that the rights of nature can contribute to shed light on the scope of state obligations to respond to the climate emergency, taking a complementary and cooperative approach, and I will describe that in the time available to me, and that we developed further in our written submission. This cooperative and complementary approach is very important. Before I do that, however, I would like to make brief reference to a question. What rights are covered by this new trend? The countries that have recognized it share a common denominator, which is that the right to exist, the comprehensive right to exist, and the right for nature to be maintained and to be able to regenerate. That is to say, that human beings do not block the life cycles of nature in developing its activities, projects, or especially when they have a medium or a high impact. And if the right of nature is impinged, there is a right to restoration as a concept different from that of reparation or indemnification, compensation. There is an important point to raise here. In Ecuador and in other countries that have recognized these rights, they are rights that pertain specifically to nature. They're not an appendix to environmental law. They grant, which gives this new idea autonomy with respect to environmental rights and environmental legislation. So much so that in the case of Ecuador, the rights of nature have been recognized in and of themselves in the Constitution. They are constitutional rights different from environmental rights, and you can see this in the most recent law in Panama, enacted in 2022. The rights of nature are also based on an idea of change. We've talked a great deal here about the whole idea that there is a perception of insufficiency when we talk about problems of how we are reacting to climate change. It's not enough. And what has been the role of legal provisions vis-a-vis the reaction. The change being proposed when we talk about the rights of nature is being based on this notion of sufficiency, making a contribution so that problems can be addressed better. This brings us the idea of effectiveness, or ineffectiveness, and we hope to be able to expand on that during the questions and answer session. This whole notion of change was incorporated by the Constitutional Court of Ecuador, for example, in a very important verdict, a structural verdict. This was the case of Los Cedros in 2021. The Constitutional Court of Ecuador, which incidentally is giving essential content to these new rights and doing so with great rigor, says that historically the law has been functional for how to make nature function better as a resource. But with these new rights of nature, the idea is different. It's not to make it instrumental. Rather, in order to achieve harmony, it is the human race that needs to adapt, not vice versa, as we have been doing from time immemorial, especially in our legal systems. But it is people who need to adapt to the processes and systems of nature. The case of Ecuador is a very good idea, a good sample of how this is taking shape in practice, and how it is starting to, and how this mentality, this change of paradigm is starting to work. All of this is based on the principle of respect. And here I want to discuss how important this principle of respect is. It was coined by the World Charter of Nature and is based on the idea of intrinsic value. This brings up a very important issue. We talk about a collaborative duality, that is a complementary approach. It's not exclusive. Environmental rights do not exclude the rights of nature or human rights. rather they complement one another. The Ecuadorian court has already offered a solution, a way out, with the principle of ecological development. So what did the court say? The sustainable development is something we're all familiar with, and it proposes, it's based on the standard of the interests of future generations, and that is good. We need to apply that. But with ecological development, by contrast, we also need to incorporate the idea of the intrinsic value of nature and its components, and do so rigorously, conscientiously, just as we do with intergenerational equity. The court has said that the use of the factors of nature is possible, but under no circumstances can it jeopardize its very existence. This is a quotation from the court's from the latest verdict from the Ecuadorian court concerning the rights of nature. Under no circumstances, it said. The court here is using terms not of minimums but of maxima, an optimum scenario. I want to close my discussion of that subject. We are talking here about, in the inter-American system, it has already been recognized that that biophysical limits have already been exceeded. The UN talks about a three-faceted environmental crisis. So what I will say in these final 30 seconds is that this new approach, which is already being applied by a number of our countries, it's an approach, a cooperative and complementary approach that does not clash with other approaches, but rather can help, especially if we use a criterion not of minimizing impact, but of preventing damage to nature. It's more. It's not just minimizing, it's preventing. And some countries feel that this is necessary in order to stand up to the challenges of the 21st century, and this is why I would cordially request the court to continue analyzing this trend and to recognize it. Some countries have already done so, and ultimately to incorporate it into the decision it makes on this very important OC. Thank you.
Thank you to your organization for your contribution to the hearing. I now give the floor to the University College of London Public International Law Pro Bono Project.
Madam President, distinguished members of the court, my name is Arif Shams, and it is an honor to appear today on behalf of the UCL Public International Law Pro Bono Project, alongside one of my fellow co-drafter, Chloe Gershon. Our submissions will focus on 1, the role of cooperation, and 2, the role of scientific consensus in the human rights response to climate change. Some aspects of these principles are not always very clearly understood, and this advisory opinion request presents the court with an important opportunity to clarify and reinforce the law and its application in particular circumstances. Our written observations aim to support this court in its work by providing relevant international as well as European source material on both issues, and we will each focus on a few key points, and we would invite you to consult our written submissions for further details and for authorities cited in support of our analysis. In this presentation, I will address the principle of cooperation. Madam President, the climate crisis is a collective problem which demands a high level of international and regional cooperation. Therefore, the interpretation of the interstate cooperation obligations in the American Convention of Human Rights is an important task before you. This court has dealt with this question in some detail in issuing its advisory opinion on the environment and human rights. However, the court's analysis was mostly based on provisions and jurisprudence that concern transboundary environmental harm and therefore transboundary cooperation. The question is, to what extent the findings of the court in its advisory opinion on environment and human rights can be extended to cooperation in the context of climate change, which demands cooperation on a regional and global level, not merely on a transboundary level. There are several procedural obligations that flesh out the general duty to cooperate in the transboundary context. These can be divided into 5 categories. 1, implementation. 2, assessment of possible risks. 3, notification and information sharing. 4, consultation and negotiation. and 5, preparedness for emergencies. These obligations are directly relevant to the obligation to cooperate in the transboundary context, linked to Principle 19 of the Rio Declaration on Environment and Development, which is different to the obligation to cooperate in the multilateral and global context, which are broadly based on Principles 7 and 27 of the Rio Declaration. We submit that the divergence between cooperation in the transboundary and multilateral levels can be analyzed by the court in 3 steps. First, the applicability of the principle of common but differentiated responsibilities to obligations of cooperation in multilateral levels. Second, obligations concerning the conduct of environmental impact assessment are more concretely defined and established in the transboundary context. There is less evidence that such assessment obligations can be applied to all areas beyond national jurisdiction for the protection of the global environment, including in respect of the atmosphere. And third, determining the scope of the obligations to notify is inherently more complicated in the multilateral context than the transboundary context. This is because determining the harm and its source requires complex calculus when multiple states are involved on the regional or global levels. However, while the principle of cooperation does not give rise as readily to specific obligations in the global context as it does in the transboundary context, there are also many similarities. As set out in our written submissions, transboundary and global obligations to cooperate do share similar goals, as said also in Principle 24 of the Stockholm Declaration. Further, there are also similar procedural obligations, such as exchange of information. In conclusion, there are many ways in which the courts can concretize cooperation in the multilateral context by analyzing cooperation in the transboundary context. However, for the advisory opinion to be legally robust, we submit that the differences between obligations to cooperate in the transboundary and the multilateral context to be recognized, and for using transboundary obligations to inform the interpretation of the multilateral obligations to be justified. I now invite Ms. Gershon to continue with the second part of our submissions. Thank you.
Thank you, Madam President and distinguished members of the court. I will address the court on the role of scientific consensus in the human rights response to climate change. In the interest of time, I will focus on the recent developments that are relevant to the arguments in our brief. I wish to draw the court's attention to the recent landmark ruling in the European Court of Human Rights of Klimasignorinen and Switzerland, which provides support for this argument. The court held that Switzerland had failed to comply with its positive obligations under Article 8 of the Convention, the right to private and family life, by failing to meet past greenhouse gas emissions reductions targets, and by failing to put in place an adequate domestic regulatory framework for limiting greenhouse gas emissions in the future. Crucially, the court relied upon, amongst other things, quote, the cogent scientific evidence provided by the IPCC to expand upon the content of states' positive obligations under the right to private and family life. It therefore held that states must put in place the, quote, necessary regulations and measures aimed at preventing an increase in greenhouse gas concentrations and a rise in global average temperature beyond levels capable of producing serious and irreversible effects on human rights. Practically speaking, this meant that states would need to implement a, quote, substantial and progressive reduction of greenhouse gas emission levels with a view to reaching net neutrality within the next 3 decades. We further submit that as scientific evidence builds and a consensus forms as to the sufficiency and viability of certain forms of climate action, the range of acceptable human rights compliant measures to tackle climate change will necessarily narrow. Whilst it is not our submission that the court should stipulate the exact measures that a state must take in order to achieve rapid decarbonisation, we do argue that the court should feel empowered to assess the policies underpinning a climate target and determine whether these policies are genuinely capable of mitigating the existing and potentially irreversible future effects of climate change by relying on climate science. We may otherwise find ourselves in a situation where a state has set an appropriate or even an ambitious target, but its realization relies solely on ineffective policies and measures. A state might, for example, pledge to achieve net zero in the next 3 decades, but the measures and policies underpinning this target rely on unproven technologies. Empowering judicial scrutiny of targets, but failing to evaluate the measures being selected to meet those targets may render human rights protection illusory. This implementation gap has already been highlighted by academic and practitioner experts. We therefore respectfully submit that this court underscores that scientific evidence must inform a state's obligations under the Convention in response to the climate crisis, and it must inform a court's assessment of the appropriateness of a state's targets and measures. This concludes our submissions. We thank the court for the opportunity to participate in these oral submissions, and we would welcome any questions. Thank you.
Muchas gracias a su universidad por los aportes a esta audiencia.
Thank you, University, for that presentation. We will now hear from Cornell Law School. You have the floor.
Corte.
Honorable Court, my colleague, Maria Anaya Corte, and myself, Anisha Umana Dayud, add our voices to the Latin American young women who are very worried about the situation. We will continue in English.
Will focus on states' obligations to protect human rights of vulnerable populations regarding the climate emergency. First, we will address children's right to a healthy environment and participation in decision-making processes. Second, we will address a holistic and intersectional approach to protect women environmental human rights defenders. Finally, my colleague will focus on the Caribbean and climate-induced displaced populations. Regarding children's, first, states must protect children's right to a healthy environment due to their particular vulnerabilities to climate impacts. This court has highlighted the need for special protective measures in the cases La Comunidad de la Oroya versus Peru and Pueblos Indígenas Tagaeri y Taromenane versus Ecuador. Children bear the brunt of environmental degradation and climate-related effects, which constitute violations to the right to life and human treatment. States must proactively safeguard children's environment, including schools, parks, and public spaces, fundamental for their development. Furthermore, children living in near-industrial areas are particularly at risk because of exposure to hazardous substances and pollutants. Second, states must protect children's rights to express their opinions freely. Courts have recognized children's standing in climate change issues, such as the Colombian Amazon deforestation case or the Mexican Tajamar mangrove case. Unfortunately, some courts have been less receptive, like the United States, where 18 young plaintiffs wait for ruling against the Environmental Protection Agency. Children have sued the government in other regions too, like in the Netherlands or India. Sometimes they could not proceed because of the lack of funds, like in the Philippines. In most cases, trial and appellate court decided that children had no standing to sue their government or companies, and it is only when they get to the Supreme Court's door that their voices are heard. Despite some successes, children have had unequal access to justice and struggle to participate in climate-related decision-making. Not all the courts are so willing to listen to the youth like this court is. Therefore, states must ensure their voices are heard. and their accounts are effectively considered in the decision-making processes. No. Regarding women environmental human rights defenders, state must take robust measures to ensure effective protection. This necessitates of a holistic, multifaceted approach that addresses the intersectional vulnerabilities of marginalized groups, including women, indigenous people, and Afro-descendant communities. 2/3 of women human rights defenders killed in 2021 were indigenous. 8 out of 10 environmental human rights defenders in the Amazon are women. While violence is pervasive against environmental human rights defenders, women human rights defenders are a specific target for sexual and gender-based violence. In rural areas, indigenous women and girls are often victims of sexual violence and gender violence. This data underscores the need for an intersectional approach that promotes women's rights alongside with climate change advocacy. State must address structural gender inequality to ensure women's participation in climate decision-making. Attempts to contribute to environment discussion may result in condemnation as bad women or bad mothers. But women's participation is critical because they're significantly more likely to die during climate emergency due to gender discriminatory reasons. Marginalized women experience rates of asset erosion, cycles of poverty, and limits on adaptive capacity. Women are often responsible for household tasks, including collecting food, water, and firewood, which becomes more and more challenging due to extreme weathers and climate conflicts. It is about time that states prioritize gender-diverse employment to reduce structural gender inequality, deepened by climate change. They must also inform local communities about how climate change affects their human rights and give them tools to report violations, ensuring that enforcement officials have received comprehensive gender-sensitive training. I ask the permission of the President to give the floor to my colleague.
Madam President and distinguished members of the court, my name is Maria Alejandra Torres, and I will be providing some observations on climate-induced displaced people and indigenous peoples. Despite the insignificant greenhouse gas emissions of most countries in the Americas and the Caribbean, they face constant extreme weather events such as sea level rise, ocean acidification, flooding, and droughts. These events not only threaten the rights to life, health, property, and food, but also force them to relocate elsewhere, even prompting them to cross borders. This is especially critical for indigenous communities, whose lands define their identity and culture. To ensure that Caribbean, coastal, and indigenous communities enjoy the right of freedom of residence and not be forcibly displaced, states must implement adaptation measures to help them cope with climate change impacts. Two cases illustrate the extent of these obligations. In the Torres Islanders case, the Human Rights Committee found that the failure to adopt climate adaptation measures, such as constructing seawalls, impair coastal communities' rights to life and freedom of culture, as climate impacts were destroying their native lands. Similarly, in La Cajonat, the Inter-American Court ruled that states have the duty to regulate and conduct environmental impact assessments to ensure a healthy environment so that indigenous peoples can continue their traditional livelihoods. Additionally, states must consider climate-induced displacement as a climate adaptation issue, which requires preparedness as well as effective and prompt responses. This court has long recognized the duty of states to protect internally displaced persons by providing them with durable solutions to address their needs. In the Mapiripan and Ituango cases, for example, the court recognized the state duty to facilitate the return, relocation, or resettlement of displaced populations. States must therefore extend these solutions to climate-induced displaced people. This is also true for cross-border climate-induced displacement. In Teitiota, the Human Rights Committee elaborated on the scope of the principle of non-refoulement to protect cross-border climate-induced displaced populations. Accordingly, states must refrain from expelling displaced people from their territories so long as a climate event threatens the right to life and humane treatment. The principle of non-refoulement applies not only to situations of sudden onset climate events, such as disasters, but also to slow onset climate events, such as sea level rise, a pervasive threat facing Caribbean nations, including Barbados, the host state of this public hearing. Being here today, we must consider that some Caribbean states face the risk of disappearing into the ocean within the present century due to sea level rise. In this scenario, the state's duty to adopt measures to protect coastal communities' right to life is even more pivotal. Cornell Law School applauds New Zealand's action to issue special visas for citizens from shrinking Pacific islands, which is a groundbreaking recognition of climate displacement as an issue requiring adaptation measures. The court should encourage present states to follow this example. Finally, these adaptation measures, however necessary, must be progressive, effective, and context-specific. While most states in the Americas are vulnerable to climate impacts, they do not always have the capacity and resources to address their population's climate-related needs. The principles of cooperation and common but differentiated responsibilities presuppose the provision of climate finance for the adequate implementation of these measures. Without finance, those most vulnerable will be paying the price, figuratively and literally speaking, of climate change impacts. The climate-human rights nexus is undeniable. If anthropogenic climate change were not an issue, extreme weather events would not have been so prominent as to impair people's exercise of human rights. Likewise, if states respected, ensured, and fulfilled the human right to a healthy environment, people would have been able to exercise the rights to life, health, water, food, property, and freedom of residence. This hearing would have even been unnecessary. Preventative climate action is therefore peremptory to ensure people's human rights, a dignified and a healthy environment for current and future generations. Thank you.
Muchas gracias. A Cornell Law School.
Thank you, Cornell Law School, for your participation. I will now recognize Dinah Shelton. Please proceed.
Madam President, honorable members of the court, my name is Dinah Shelton. Thank you for according me the privilege of speaking to you this morning as a retired professor. The last time I appeared before this court, it was as president of the Inter-American Commission on Human Rights. So it's an honor to be here. And thank you to everyone who participated yesterday and today. Following on some of the comments of IUCN, I will focus on the state obligations that the court articulated in its first contentious judgment and has reiterated in many opinions since the time. The first of the obligations that a state has is to recognize the rights and freedoms and respect the rights and freedoms recognized by the Convention, making the state responsible for the acts of its agent in their capacity, even if the acts are outside the scope of their authority or in violation of internal law. Motivation or intent is irrelevant. Secondly, the state must ensure the full and free exercise of the rights recognized by the Convention. This implies that the state must prevent violations of the rights recognized by the Convention. In addition, the state must make good faith efforts to investigate, prosecute, and punish violations of human rights, restore the right violated, and provide compensation as warranted for damages resulting from the violation. In the case, Honduras was found not found, the evidence was not clear on its commission of the acts of disappearances. However, the court found that Honduras failed to fulfill the duties to ensure the full and free exercise of human rights. Responsibility was imputed because of a lack of due diligence to prevent or remedy the violations that were committed. Today, one of the international obligations imposed upon states by treaty and custom is to respect and ensure internationally recognized human rights. Because of this duty, a state's failure to act to prevent or remedy human rights violations contributed by state or private entities may constitute the breach of an international obligation, giving rise to state responsibility. In respect of economic, social, and cultural rights, the obligations are also those of due diligence, although constrained by the state's capacity in many instances to do so. The constraint does not apply, however, when the alleged violation concerns the recognized minimum core of right. This is crucial in cases where the rights involved are a right to water or the right to food, for example. Since 1972, the obligation of due diligence has also appeared in numerous environmental conventions, which have obliged the states parties to take appropriate or similar measures. In addition, international courts and tribunals have spelled out the due diligence obligation with regard to land, watercourses, and the marine environment. It is especially due diligence facilities dealing with uncertainty in the face of a plurality of diverse actors and varying risk proximity. In international climate law, proximity is contingent both on the state resources for action and on their past contributions to climate harm, making the capacity of state a relevant factor. It is important, especially in cases in the situation of climate change. Obligations for the prevention of harm to the environment generally require a state to act with due diligence in respect of the activities of public and private actors. The development of law on due diligence is largely derived from the ILC's articles on the prevention of transboundary harm, which provides that the state of origin shall take all appropriate measures to prevent significant transboundary harm or in any event to minimize the risk thereof. The question is, what are all appropriate measures required of states in confronting the known consequences of global climate change? The ILC articles specify that the measures to be taken are those generally considered to be appropriate and proportional to the degree of risk of transboundary harm, also using the term a reasonable standard of care. So the two factors that make up the duty of due diligence are the possibility or probability of risk of harm, and the second factor is the magnitude of the harm. So the greater the magnitude of the harm, the less you need to have the probability of the harm occurring. In the case of climate change, we have risks that are absolutely known, and yet it's a variable concept based on due scientific or technical knowledge covering the risks. States are now bound to make the best possible efforts to ensure compliance with their obligation, especially taking measures reasonably appropriate. Some obligations are further indicated as the ITLO's chamber decided in its advisory opinion. These include enforcement measures such as implementation of the precautionary approach, adoption of best environmental practices, and conduct of environmental impact assessment. It's a standard of reasonableness that avoids perfect equality of obligations in favor of a more flexible approach. This is particularly important because the concept of common but differentiated responsibility informs what diligence is due. This is justified by three factors. The first is the need to adopt environmental measures that are designed and implemented in such a way as to support states in achieving their development objectives. Second, the responsibility of development states for environmental damage, at least since the Industrial Revolution, and their disproportionate consumption of the Earth's resources, plus the contributions to climate change. Demand that they accept the major burden to combat the global problem. Third, develop states of greater financial and technological ability to meet the cost of transition toward more environmentally sustained resources. Due diligence tends to focus on whether states have taken reasonable and appropriate steps to prevent or mitigate damage. I will finish by recalling what this court said in the Laroya opinion recently. States have recognized the right to a healthy environment, which entails the obligation of protection that concerns the international community as a whole. It is difficult to imagine international obligations with greater transcendence than those that protect the environment against unlawful or arbitrary conduct that causes serious, extensive, lasting, and irreversible damage to the environment in a scenario of climate crisis that threatens the survival of species. In view of the above, the international protection of the environment requires the progressive recognition of the prohibition of conduct of this type as a peremptory norm, jus cogens, that earns the recognition of the international community as a whole as a norm that does not admit derogation. This court has pointed out the importance of the legal expressions of the international community whose superior universal value is indispensable to guarantee the essential of fundamental values. In this sense, guaranteeing the interest of present and future generations and the conservation of the environment against its radical degradation is fundamental for the survival of humanity. Thank you.
Thank you, Ms. Shelton, for your interest and for participating in the hearing. I now give the floor to Soledad Garcia Munoz and Erin Daly. Thank you, Madam President. I am Soledad Garcia Munoz. I will be speaking in Spanish. It is an honor to participate in this hearing along with Professor Erin Daly, Professor and Director of the Clinic on Dignity Rights from Widener University of Delaware Law School, and I am Drinan, Chair of the Institute of Human Rights and Visiting Professor at Georgetown Law School. I respectfully greet this honorable court and the delegations of the requesting states in this historical advisory opinion. I profoundly welcome the initiative. I also remember that the last time I appeared before the court was precisely at the hearing on La Oroya versus Peru. So special greetings to the delegation of the Commission participating in the hearing today, which is very significant for me as we are seeing each other after I've finished my mandate as its first as a special rapporteur on ESC rights in August 2023. It is following the logic of the necessary synergy between the Inter-American Commission and Court, we should highlight the progress both regarding standards and work under the climate emergency in the Commission, which are evidenced in several standards and reports that I led being at Redesca, to which I will refer. Some of these include Resolution 3/2021 on the scope of inter-American obligations regarding the climate emergency. This document, unanimously approved by the Commission in December 2021, is a first set of inter-American standards on the matter, and it was prepared after an ample process of 2 years of consultation and public hearings, with participation of several organizations and states that are also participating in this hearing. It was articulated around 9 themes identified at the different environmental and climate fora. I had the opportunity of representing the Commission and the OAS in 3 successive COPs, where I could see how, unfortunately, the concept and approach of human rights is absent from the most significant negotiations in the agenda. In that sense, this advisory opinion is also called upon to be a tool for climate negotiation for all states of the OAS. Considering the written submission of the Commission focusing on this resolution, and then the court itself is also echoing the judgment of La Oroya case, I won't go into the content, besides manifesting that it is also based on the principle of indivisibility and independence, and it opens a good dialogue with several of the topics we have heard this morning regarding the intersection of international human rights and international environmental law and the largest climate change instruments, or the Escazú Agreement. Since 2017, after the judgment Lagos del Campo and the Advisory Opinion 23, after Redesca was created by the Commission, and today the inter-American system has gone through a sort of revolution, in the best sense of the word, regarding development of standards, monitoring, protective measures, and consultative jurisprudence, as well as contentious jurisprudence regarding economic, social, cultural, and environmental rights. So we can see that it was inevitable to take these on, considering the context humanity is now facing, whether the pandemic, poverty, and inequality, or the climate emergency. Throughout the process, the Inter-American Court, starting with the Honduran cases, and to date, has always been characterized by using the pro persona principle, and it is called to innovate, taking advantage of the great opportunities and hermeneutical needs that this process offers, not just the states under its jurisdiction, but for the whole hemisphere. We also hope they can work with the pro natura principle by developing paragraph 62 of Advisory Opinion 23. We believe it necessary for the court to speak with a distinctive voice, and not just speaking for the inter-American community of nations, but also to serve as a global model regarding the responsibilities of states facing this climate emergency, as we've heard, that has led to catastrophic, irreversible damage and knows no borders, only of common responsibilities, though differentiated. We would also like to take the opportunity to focus on some of the features of a singular or unique inter-American approach based on our written observations and throughout the process, inspired by it. We will focus on 2. If possible, we will add the other 2. If not, we hope to be able to do so during the questions. We will refer to indivisibility, dignity, and if time permits, we'd also like to add protection against damage, gender, and intersectionality. As we hold in our written observations, the process presents us with a historic opportunity not just to reaffirm indivisibility, interdependence, and interrelation of all human rights, as many times the court has done so, the Commission and the Working Group on the San Salvador Protocol, but to more explicitly state the need to apply the perspective of indivisibility, interdependence, and interrelation, which necessarily means to incorporate the perspective of ESCE or ESCEN or I rights, as we are hearing from indigenous peoples, to include their indigenous rights to the economic, social, environmental, and cultural rights. In this climate emergency, especially considering what this entails for states as well as the actors under their jurisdictions that produce most GHG, which are companies and corporations. This is a wonderful opportunity for the court to delve deeper into inter-American standards in terms of business and human rights. And as we've seen in the report regarding this under Redesca from the Commission in the Loroya case. In considering and developing the perspective of indivisibility and interdependence that we suggest the court embrace as an explicit hermeneutical criterion, it would be also good to reconceptualize indivisibility of all human rights and of human rights towards nature. The perspective of indivisibility is at the very heart of the inter-American system. The American Declaration, the OAS Charter, the American Convention, the San Salvador Protocol. And it entails understanding that rights operate together and that courts should adopt a holistic vision as to how people can enjoy and employ their rights as individuals and human groups. Seeing I have no more time, I will give the floor to my colleague, Erin, who will continue.
Thank you very much. Thank you, Madam President and distinguished members of this court. I am honored to be here today to have the opportunity to speak with you on this historic occasion. I will speak briefly, echoing much of what has already been said in this panel and complementing what my colleague has said, but really focusing on the idea and the law of human dignity. I want to make just a few very brief points. As we heard this morning, when a child can't learn because the heat is unbearable, or when a family's home is devastated by floods and fires, people don't experience that as a violation of one enumerated right or another. They experience it as a harm to the soul. They experience it as a harm to their human dignity. And the law must and does reflect this. We know this already, right? It's in the American Declaration. It's in the UN Charter. It's in the article, the preamble in the article, first article of the UDHR, as well as the sort of common articles of the two international covenants. In fact, the principle of dignity is so well recognized that this court, in the recent La Arroya decision, affirmed that life and human dignity, peace and security are, in fact, jus cogens rights. Indeed, international law and the law of the inter-American system have united the right to life and the right to dignity, such that the right to life is defined as the right to live with dignity. This is made explicit in the UN Human Rights Committee's General Comment 36, and it's reflected in the long-standing jurisprudence of this court as well, most notably perhaps in the Street Children case of 1999, which is the best known affirmation, or one of the known affirmations, that all people, including children, have the right to live with dignity. This right to life with dignity contains within it all rights indivisibly that are necessary for a life of dignity of all people, including a stable climate. There is no jurisprudential area in which the dignity basis of the right to life is more pronounced than in the context of our compromised environment and the climate crisis that we face. Again, this court laid the groundwork for that in the La Arroya case, noting that included the protection of the environment as a condition for a dignified life. And this was also amplified and applied to the context of climate change in the Daniel Billy case, which was mentioned previously. The right to live with dignity has certain jurisprudential implications, and I'll just mention two very quickly. One is that the right to dignity is inviolable, and therefore state power must yield to the demands of human dignity. As a jus cogens right, it is non-derogable. As this court said very directly in the La Arroya case, the exercise of public office has limits that derive from the fact that human rights are inherent attributes of human dignity and consequently are superior to the power of the state. Second, a dignity focus to the recognition of indivisibility softens the lines that sometimes the law arbitrarily draws, because as we know, people who experience climate change effects don't draw these lines. They don't draw lines between civil and political rights and social and economic and environmental rights. They don't draw lines between substantive and procedural rights. They may not even draw lines between human rights and the rights of nature, as was mentioned earlier. All of these are related to the experience of life on Earth with dignity. And of course, this is especially true in the context of climate change, as noted by the General Comment 26 of the Committee on the Rights of the Child. What the committee said there relating to children applies with equal force to many other populations in vulnerable situations. Given the strong support in both international law and this court's jurisprudence for the recognition of the indivisibility of rights rooted in human dignity, including in the context of climate change, we urge the court to build on its case law on the work of the Commission recalled by my colleague and to recognize a right to a stable climate, whether as a standalone right or as an incident of the right to live with dignity or included in the right to a healthy environment. I'll give the floor to my colleague to conclude our intervention.
Thank you.
Thank you, although our time is up, so thank you so much. Thank you.
Probablemente durante las preguntas van a tener más espacio. Muchas gracias por su participación a ambas. Corresponde ahora el bloque de preguntas de las señoras juezas y jueces.
We will now have the questions from the judges. Patricia Perez Goldberg, do you have any questions? Yes, Madam President, and thank you. I would like to ask about the Ecuadorian experience that you referred to. It is interesting to see, as you just said, that there are different legal orders domestically that have changed their constitutions to include nature as a subject, as a bearer of rights in a direct manner. In your view, how, and let me rephrase this actually, what source of law or regulations or what interpretation could be relied on to do that under the American Convention that is not a constitution, and as opposed to the Constitution of Ecuador that is under review and that is from 2008. It does not allow for that, and so how could that be done? Thank you. The Ecuadorian experience is 15 years old already, and it has been developed quite interestingly because Ecuador is a civil law system country, has been developed by our constitutional jurisprudence, and that's something that I'd like to mention by way of background information. So, indeed, within the inter-American system, this idea of the rights of nature is not present, but the concept underpinning the rights of nature, which is the principle of respect, which is in the International Nature Charter, could be used in conjunction with the Protocol of San Salvador. That's one choice, and also there's Article 26 of the American Convention that should also be taken as a basis. Why am I saying this? It's not only Ecuador, but also other countries that have incorporated this new legal concept, and that is why we speak of models. The Ecuadorian case follows a model of constitutional reform, but it's also a very interesting case where there has been jurisprudential development without recognition, which calls for more efforts. And in the Panamanian case, it's more legislative models that have been adopted. Thank you. Just one additional question to make this easily understood. I might not have made myself clear with my questions. One thing is for a state to establish its own domestic deliberation procedures and dialogical procedures to be able to make changes to its constitution, for example. But a completely different thing is an international treaty where there is no such procedure for amendments to be made. So based on what provisions of the American Convention, and how would you think that nature could be seen as a bearer of rights in the framework of that specific treaty, you know, above and beyond good practices? I mean, it's a different thing altogether. The Article 11.2 of the Protocol of San Salvador may be the best way to analyze this issue, and as a way into the system, into the inter-American system, the right to live in a healthy environment. Thank you.
Thank you, Patricia Perez Goldberg. I would now ask Judge Veronica Gomez whether you have questions. Yes, ma'am, I do. First of all, once again, Dr. Echeverria seems to be much in demand right now. My question has to do with the rights of nature, which was the point of your intervention, or your submission. Perhaps you could add a cross-border perspective. I know that's what we're here for, because this is, after all, an international court with a region-wide jurisdiction. So we all know that schools of fish, and that herds, and that algae, and that insects, and that microorganisms do not much care about human geography and do not respect political borders. So you have brought up some very important examples involving domestic rights, recognizing this right. But how can this dimension work, the cross-border dimension and the dimension of global climate change, recognition, when we talk about recognition of the rights of nature? Thank you. The nearest example I can think of, I will talk about climate change, but the most accessible about ideas going beyond the limits of a country has to do with marine species. It's the blue perspective of the rights of nature, which has not yet been examined in depth, but it will soon happen, because in all of our countries are parties to two treaties, the CITES and also the Convention on Migratory Species. There is a problem right now with the management of shark and stingray species. There is a problem with exports, which are not sustainable, and which has been raised by the Secretariat of the CITES Convention. Right now, Ecuador is banned from trade because there is evidence of overfishing. The issue, then this was raised by Peru. The case was raised by by Ecuador's neighbor, Peru. And what the CITES Convention will do will be to examine, Ecuador will be asked to submit arguments for the ban to be removed. So they will have to talk about their fishing industry, standards for protection of wildlife, which is generally where this is analyzed. But also, Ecuador will have to show standards of the rights of nature, which are already set by by Ecuador's Constitutional Court, and this will happen as soon as the CITES Convention re-examines this very specific case. Add to this the issue we're talking about, which is migratory species. All of the states represented here have signed the commitments. Something very similar. This subject will also be open the door. All of this is new, by the way. That's why the answer is not simple or even concrete. But all of this will start to show how the issue is taking shape and how it could be used as a way to examine commitments regarding climate change. That's fascinating. Thank you.
To be continued. I have a second question. This is for UCL, for Ms. Shams. In some of the discussions, there was a theme yesterday of changing paradigms with the same tools. So what you're proposing is that we use the tools of environmental law in connection to climate change. And you propose some sort of test saying that there should be, if I understood correctly, some sort of comparison between the elements of transboundary harm and, you call it sometimes multilateral or global harm. Does that mean that you're saying that we have to use the paradigm of environmental law, of classic environmental law, when we're facing our current dilemma with climate change, please?
Thank you, Your Honor, for your question. The main concern that we had when drafting this part of our amicus brief was that in the request for advisory opinion, there was a simultaneous mention of Principle 7 and Principle 19 of the Rio Declaration. Now, Principle 7 talks about cooperation in the global context, and Principle 19 talks about the duty to notify in a transboundary context. And so the risk here the risk that the court needs to be aware of is to not conflate those obligations that relate to the transboundary context with those obligations that relate to the multilateral context. Now, in the interpretation of the obligations to cooperate in the multilateral context, I think it is all good and well to draw parallels with the rich jurisprudence that has been developed regarding transboundary cooperation. The only point to be aware of is to recognize the differences. And so the differences that we have mentioned in our written submissions, for instance, would be the differences in the content of the duty to notify, which is different in the transboundary context versus the multilateral context.
But allow me to interrupt you because we have limited time. But you said the court should acknowledge differences between the two, the transboundary and multilateral, and justify going beyond elements of transboundary harm as some sort of test. But at the same time, notification, information, assessment of risks, very different, pollution case from what we're discussing here in this hearing.
Thank you, Your Honor. Yes, precisely. And that is our point as well, in the sense that when the obligation to cooperate in the context of climate change is being interpreted, the point to be aware of is that this is different from the exercise that the court conducted in its advisory opinion on environment and human rights. And it's exactly the point that you just mentioned, that these obligations in the transboundary context that could go to the traditional environmental law cases, like the Trail Smelter or Lake Lanu, or more recently pulp mills, they are different to the way in which the obligation to cooperate should be interpreted in the climate change context. Thank you.
Tengo una pregunta para...
I have a question for Soledad Garcia Muñoz. And I would particularly like to greet you and the predecessor of Javier Pulmón, who is sitting here as well, the current rapporteur, and Professor Bailey. How do we understand the right to a decent life, a life of dignity, with this element that goes beyond borders that we're talking about. Thank you. Yes, I will try to add to what has been said, because quite certainly your question goes in the same direction that we had wanted to contribute to this honorable court. To express the indivisibility. It's a topic that's already being developed and has come up throughout your case law. It's not only with application to the cases of fishing. This right to a decent life, of course, will open up this perspective of indivisibility and the perspective that we would like you also to adopt expressly, explicitly, and in the recommendations that you offer to the states and the cases in this advisory opinion and in the cases that will examine climate issues, understanding that the climate emergency, in fact, is addressing the right to life in its maximum expression, and in this sense, all the human rights that allow us to lead a decent life. My colleagues already talked about the case, the street children case. So I will take advantage of your question in order to suggest, because these sessions have been very inspiring, I must say. So even as we consider the possibility of adopting a perspective of indivisibility and interdependence as an express hermeneutic principle that, of course, will lead to the right to life, as Judge Cansao Trindade said so clearly, nevertheless, it does not pertain only to civil and political rights, economic rights, social and cultural rights. Instead, it's the maximum. It's the most primordial right. But also take into account the possibility of taking a climate perspective in all of the cases you hear in your jurisdiction, because I think that this request and this process are bringing new hermeneutical standards that need to be made more explicit, not just naming them in certain paragraphs, because unquestionably they are tools that are necessary. I would like to recognize my colleague so that she can expand on this question, on this matter.
Thank you. I don't have very much to add, except that I think that explicitly recognizing it as a jus cogens right imposes on all states obligations to respect and guarantee that right to people all over the world. And even outside the context of climate change, there are many cases where one country is responsible for violations of dignity of people in another country, and that jurisprudence is part of this. The climate change aspect is just one example, one application of that. Thank you.
Thank you. La última pregunta, prometo, señora.
Last question, I promise, Madam President. The last.
Former President of the Commission, Professor Shelton, thank you so much for coming. Thank you. There's so many elements which you brought in your intervention, but you finished quoting La Orocha. And on Monday there was a seminar here, and we were talking about the intergenerational nature of the impact. Of the inter-American system cannot assess impact without this intergenerational view. And while La Orocha was being drafted, I'm sure some of us were thinking in those terms. We had many jurists in mind, and of course, through some of our minds came, what would Dinah think about this? So the question is, what do you think about this provision? Because the court only says, well, let's hope the international community, this emerges. It doesn't emerge just because the court says it emerges. So what do you think? Thank you.
About intergenerational equity?
No, about the prohibition of serious, extensive, lasting, and irreversible harm to our environment. It's a jus cogens.
Well, I agree that it's a fundamental value in the international community, and it's based it's linked to the right to life, which is always a jus cogens obligation. So I think the recognition is justified in this case. Serious and irreversible harm is one of the aspects, one of the two aspects that is part of the analysis on the duty of states to take reasonable measures. And in this case, if you recognize it as jus cogens norm, the measures that have to be taken are much more evident than they would be otherwise. Although I tend to be skeptical of jus cogens norm in general, you know, I don't know. This is a tough question. I have been skeptical of the recognition of jus cogens norms in the past because I think it was overused. But I think in this case, although I'm divided on it, I think it's probably justified.
Thank you very much.
Oh, and if I may comment on the rights of nature. Remember your Human Rights Tribunal. It's rights of humans. And I think that although we're part of nature, we're somehow different in relevant aspects. And we have rights that will never be transferred to flowers or mosquitoes or any other species. And I think that's right. Your instruments, the instruments of the Inter-American system, are instruments of human rights. And I would just caution you not to go too far and recognize the rights of nature at the international level. I don't see a basis in the treaties for doing that.
Thank you. Thank you. Okay.
If may it please the court, I would also like to answer the question about the rights of nature. I would believe that even though there is no explicit mention of the rights of the right of nature in the convention or in the protocol of San Salvador, I do agree with the first speaker in the sense that the right of nature can be drawn from Article 1 of the Convention concerning human rights, and also the second paragraph of Article 11 of the Protocol of San Salvador. I think it is important to understand that the rights of nature are important not only to protect nature per se, and to have that vision of ecosystem and the anthropogenic nature of the crisis, but also to be able, in a sense, to give, to extend certain rights or legal standing to rivers or the Amazon, for example. It could be, such a measure could be very important for lending greater enforcement capabilities for protecting nature per se. And this would generate a benefit regarding the sinks, the carbon sinks, because we understand that the nature of the oceans and such natural resources could contribute to lessening carbon emissions. So I think that there are resources in the framework of the Inter-American system and the Inter-American Court to recognize this right. And furthermore, there would be a great deal of benefit not only for reducing emissions, but also for protecting the rights of indigenous peoples. Thank you.
Thank you, and thank you, Judge Gomez. Judge Ricardo Perez Manrique, do you have questions? Yes. I also wish to acknowledge Professor Shelton for appearing before us today and Thank you so much for your very important contributions. I had also wanted to ask about use cogents. But because you jumped ahead, or Judge Gomez asked before me, I would like to ask, why are you pessimistic? We are dealing with an issue that seems to imply a risk for humanity's survival if it is maintained. So if you, with your track record and experience, do not believe that these rights should be seen as use cogents, and we discussed this yesterday also, it couldn't really be a contribution in this sense for this matter, especially if we're talking about obligations of states.
For your question, I'll take this up. One of the things that was said in jus cogent at the end of La Roya was that the importance of the legal expressions of the international community, whose superior universal values indispensable to guarantee the essence of fundamental values. That's a good test for jus cogents, and I just wonder if every pronouncement of jus cogents in the past has met that test. I did a study once of all the mentions of jus cogents in the literature, and I came up with 900 different values that were claimed to be jus cogents, including the right to life for whales and the duty to assassinate dictators. I'm not sure how many of those would pass muster under the test you set of universal recognition of a fundamental value. This, because of the dangers involved in climate change, I would agree that this probably meets that test.
Thank you very much. I'd like to ask another question that you have not necessarily developed in an area you have not developed necessarily, but I wish to hear your opinion. What are the connections or the implications, considering the climate emergency, the right to development? So how is it connected? Many times states, and especially as we've heard, states in a region that is the most unequal in the world, choose investment and conditions for investment to come that are detrimental to fighting climate change. So this potential conflict between the right to development on the one hand and the other hand conservation and fighting climate change. If you could please, I would like to hear your considerations.
Thank you. The right to development is, of course, a very important value in the international community, but it's not itself a human right. It's based on a combination of the different rights that take place. And in the environmental field, the right to development has been recognized that it must be balanced by the right of a healthy environment. And I would include within that climate change. The duty of host states is to regulate any investment, to enforce the regulations, and to provide remedies when rights are violated. And I think if that is done, if existing laws and new regulations are fully enforced, the right to development can proceed with proper investment. I think investment treaties are always subordinate to human rights. This was recognized by the court in several cases involving indigenous people. So that's the duty of the host state. The duty of the home state is to also have regulations on their companies actions abroad. And I think a combination of the two will allow development to proceed without being in violation of fundamental rights.
Thank you very much, Professor, for your kind answers. As for Soledad García Muñoz and Professor Daly, there's an approach linked to this last question, by the way. And it is how states are obliged to regulate companies' activities and the fact that these activities do not make the climate emergency worse. Thank you very much, Judge Perez Manrique, for the question. This takes me to precisely one of the points that we could not develop because of time constraints. And it's also the opportunity the court has with this advisory opinion of inter-Americanizing standards on business and human rights. One trend that you've already contributed to in your bigger cases, not just in La Oroya, but also in mosquito divers, buzos mosquitos. I think it requires, and this is a very good opportunity for that, to bring inter-American standards to understand responsibilities of businesses and obligations of states in terms of guaranteeing and respecting. I use these two terms because they refer to the specifically inter-American obligations, where we have the report on business and human rights and inter-American standards. The obligations of states regarding their business activities, respecting and guaranteeing. And under the duty to guarantee, they have to prevent, regulate, repair, redress. And we believe this is a golden opportunity, if I may say so, to have the court make these standards inter-American, if you will. And the court has already considered this in its La Oroya judgment. And it goes through an analysis of how the context of the climate emergency is one of the most concerning in terms of business and human rights, and how already the inter-American system has tools besides the guiding principles on business and human rights that, as we said in that report, might be a good starting point, but it's not the end point. There are several inter-American tools to really bring this to the inter-American system. Of course, I could talk for hours on this, but if I may, I would like to, if the President allows and the court allows, I would like to give a more specific written answer as to this, because the climate emergency and the role of businesses and companies in the production of GHG emissions, and also extraterritoriality that we've heard in this hearing, also covered in that report I alluded as one of the inter-American criteria that are of special transcendence for business and human rights. So it would be a wonderful opportunity for the court to develop this, along with another inter-American criterion, which is fundamental. And here I have to refer to the question that was posed to Professor Shelton. Development. The right to development as a fundamental inter-American criterion on business and human rights, taking into account development in how it refers to sustainable development, not just as economic growth. And that precisely is the limit that you, as Inter-American Court of Human Rights, could offer, should offer. And if I also may take some license in terms of creativity, I think the court has already used its creative powers before, and I think that during this advisory opinion you can be very creative as well. Who you can address your recommendations to. Of course, states are your natural counterpart. However, I believe it would be very good, as we've also noted in this report, to also consider what types of guidelines you could offer to businesses, companies, what types of guidelines the actors in the inter-American system could receive from the court, and also for international financial institutions. Yesterday, Judge Veronica Gomez asked questions in this sense, and I think it is really worth it for the court to consider these other actors as principal stakeholders in this advisory opinion as well. And to close, I also wish to refer to rights of nature. I understand Professor Shelton's concerns in this regard, but I also believe this is a historic opportunity that very few, if not just you, as an international court at the forefront of human rights have. It's a historical opportunity to refer to these rights and talking about the indivisibility and interdependence also through Article 29 of the American Convention. That has not yet been mentioned, the valuable progress in terms of national jurisdiction in places like Colombia, Bolivia, Ecuador, and I think it would be a critical contribution to our times and to this emergency. Thank you. Thank you very much. And the last question on the rights of nature, following the lines of the question by Judge Perez Goldberg. This is an international human rights court. Its role is to interpret and apply the American Convention on Human Rights. So the question is, what is the relationship between the right of nature, and Professor Shelton has already given a remark on that fact that human rights are rights of humans, not of things. And to date, at several courts, this matter beyond country courts in our region has really been handled as a pro natura principle of interpretation. So the question is, you are suggesting that it is a human right based on what? And if so, what arguments do you have for this? And what could help us acknowledge it, but also interpret and apply the pro natura principle to all cases such as the one we have? Thank you. First of all, I should highlight that the concerns regarding the rights of nature are valid, but on the other hand, the experiences we see in American states can help lessen these concerns. The argument of no weakening or competition of human rights if we add rights of nature is there. The fact that they are complementary to each other and they are indivisible. This is the message to convey. We hear the concerns, but based on our experience, it shouldn't be major concerns if it's just a matter of how to articulate them. Secondly, in the written observation that we submitted, we are talking about human rights, and of course we understand and respect that, but we are saying that we should move forward. You should progress on what has already been stated before. In American states, this is a fast-growing trend, maybe so fast that we still cannot grasp it 100%. And third, that if it may serve the court, it can consider the theoretical bases of the rights of nature, which are based on instruments of the United Nations, specifically the principle of respect. So we are not asking to include in the logic of human rights, to include nature in the logic of human rights, but to acknowledge that besides human rights and the right to live in a healthy environment, there's this new trend that is quickly developing, and that it could help the court address this very complex issue from anything that can, and that the rights of nature can contribute. If you follow the logic of environmental law, nature is something to protect, and that's very fine. And La Oroya develops this, and there's a manifest concern for nature. But if you look at the rights of nature, the logic of the rights of nature, there's no longer that protection. There's respect. So there's greater rigorosity. It's greater strictness, and all countries are applying this as a satisfactory solution. Thank you very much for your answer. No more questions.
Gracias, Juez Pérez Manrique.
Thank you, Judge Pérez Manrique. Go ahead.
Is not to weaken environmental law. There are hundreds of treaties on everything from endangered species to migratory species, and the Montevideo program that UNEP has worked on to get its 10-year program for work every decade, it took 4 decades to get them to recognize the human right to a healthy environment. And I'm just worried that the arguments that are being made will somehow weaken what is already regression in the environmental field. There have not been any developments that are strong in the environmental field in years now. Every session, from the Stockholm Declaration to the Rio Declaration to the Johannesburg Summit, retreated on human rights. And I think both human rights and environmental law could be endangered. That's all.
Gracias.
Thank you. I am going to ask Judge Ferrer Magregor if he has any questions. Just one question, cognizant of time, of course. Certainly. For Soledad Garcia, at some point you mentioned poverty, and I wonder if you could, in very specific terms, link that to the obligation to respect rights, Article 1.1, and the issue at hand with this, which is the climate emergency. Thank you very much, Judge Ferrer Magregor, and especially structural poverty, if I may add. Thank you for this question, because in terms of indivisibility and interdependence, this perspective creates an opportunity to tie and link rights explicitly through hermeneutics, as you have done in practice, but also to interrelate the factors and tie them, those that enable human rights violations and the violations of economic, social, and cultural and environmental rights, as was the case during the pandemic. If there is a structural condition that affects human rights, one of the major issues surrounding human rights in our region, because it's the most unequal region in the planet, is poverty, multidimensional poverty, which also calls for a specific approach. And there is an advisory opinion that is not very much used by this court, which is OC11, which also makes us think about what the access to justice is for those people who are living in poverty. So there is an Inter-American Corpus Juris related to poverty and human rights, and the Inter-American Commission on Human Rights in 2007 issued a report on poverty and human rights. The pandemic has shown poverty and placed it at the center of everything. And this is a huge opportunity to apply that approach of poverty and human rights from the viewpoint of poverty. And that is something that I have had a chance to work on extensively together with the Commission. And the climate emergency from the point of view of gender, of feminization of poverty, of intersectionality, that has also been developed by you in a very novel and clear fashion based on the Gonzalez-Jui case, should make us wear those glasses of gender and intersectionality to view human groups who are most vulnerable in face of the climate emergency. And based on my experience and my commitment, the largest group of people in experiencing this crisis and at risk are people living in poverty, in extreme poverty, people living in the street or who will end up living in the street, on the streets, or those who are part of the informal economy, those who work in recycling, for example, and they have no labor rights upheld. So this is an opportunity to have these persons who live in poverty or in extreme poverty, or who do essential work, such as people who collect recycling materials, as I have seen oftentimes during on-site visits during my prior mandate, my term in office, that a recognition, expressed recognition be made of these persons living in poverty. This deepens poverty, deepens inequality, and calls for reinforced measures to be taken by states to protect those living in poverty and extreme poverty. Thank you very much. Just briefly, about the issue of poverty, which is germane to this topic. Climate change and the environment force us to take a holistic view of what is happening. Poverty is hitting vulnerable populations, and climate change is exacerbating that. If we were to compare this to the Industrial Revolution, back in the past, we see a faceless phenomenon where we don't know who's responsible, that led to an accumulation of capital and increased poverty. So the pandemic, as my colleague was saying, is yet another example. Climate change is the most powerful example we have. It is affecting vulnerable populations directly, and nobody is protecting them from this being exacerbated even further. And that's why indigenous, Afro-descendant populations, women and children, do not have the tools to fight this monster of climate change that does have stakeholders are responsible for them, but are not so easily identified. Thank you. Thank you, Judge Ferrer Magregor. The Vice President, Judge Perez Goldberg, would like to ask a question.
Thank you, Madam President. Professor Shelton, thank you very much for your comments, which were so specific and clear. And you did mention an issue that we have been discussing already over these 2 days of hearing. It seems like more than 2 days, doesn't it? But it's been only 2. In the La Oroya case, I looked back to see what it was we said specifically about recognizing the right to a clean and a healthy environment. Paragraph 118, it says, with respect, the court recognized that the right to a healthy environment is a universal interest and a fundamental right for the existence of humanity. I would like to put that together with what you're saying. Sometimes there's something we're very clear about, but even so, we need to reaffirm it. In this case, it's that the American Convention is the American Convention on Human Rights. So, because you are here, I would like to take the opportunity to ask you to clarify the difference between domestic legal structures, constitutions, and laws, and the international body of treaty law. You have said that from that perspective, and considering the nature of these instruments, we have what you mentioned, which I think is relevant. So, because you're here, I would like to take the opportunity to ask you to clarify these differences between good practices and things that you might consider to be very positive in domestic legal structures that were preceded by freely democratic processes in the countries, and quite differently the situation of international treaties. Please.
Thank you for that question, which is very difficult, but I'll make my best efforts. The domestic measures that are taken must always be judged by the requirement of due diligence, which is the standard under which the Inter-American Convention judges all domestic measures, all regulatory measures at whatever level, whether in a federal system or a unitary system. And that means that good practices will have to be judged by that standard as well. With, I suppose, some deference to the decision-making at the local level, but not a great deal, because the Inter-American system, of course, has its own standards that have to be applied consistently and fairly. The question is whether the measures are reasonable and appropriate to the risks involved and the magnitude of the threatened harm. And if they pass muster under that standard, then of course they should be recognized and given effect. If they don't, then they need to be revised so that they are adequate to address the issue. I hope that answers your question.
Yes, so specifically in terms of the consideration that the court will give to domestic measures, but maybe you could be more specific and go into more depth. You said something about about the discussion of the right of nature in the context of the American Convention, and that we are in a different situation. The American Convention is not a constitution. The Inter-American Court is not a super-constitutional court in any country of the Americas. So maybe you could talk about that difference.
Thank you. So I turned it off. Yes, the Inter-American Court is bound by its jurisdictional limits and the language of the treaty. Domestic constitutions can be amended to put in whatever they think is appropriate for the country consistent with human rights. And the same for domestic laws and regulations. So the court has to implement or enforce the rights that are in the American Convention and the Protocol and the other treaties in the system. You're not able to go beyond that language to put in rights that aren't there. And I think the rights of nature aren't there. However much it may be good policy, that's a policy that will have to be left to the domestic arena.
Thank you. I have no further questions, Madam President. Thank you. I do have a quick question I would like to ask.
I'd like to ask you about... if I may, I'd like to ask you, Professor Shelton, as well. You've mentioned this on your written submission. And it is about the human right to resilience. Could you please expand during this hearing? Expand on that concept and how it is related to the right to life as you've developed it.
Resilience is a right to this rapidly developing and recognition. It's based on the right to life, and it requires that states take action to ensure that humans will be able to survive. And that means addressing the most vulnerable as well as the majority of the population. Actually, the majority may be the most vulnerable. But taking action to ensure survivability of the species. And in that regard, any actions that the government takes has to be consistent with the right to resilience, and it means non-regression, not going backwards in terms of the level of protection.
Muchas gracias.
Thank you very much. Judge Mudrovich would like to ask a question. Go ahead. Thank you very much, Madam President, and I wish to apologize for jumping in, but your answers, Professor, are so interesting that I would like to go ahead and ask you very respectfully. If there's no inconsistency, then while you're defending the right, the human right to resilience, which is a right that is not in the text of the convention, you are also very cautious and pessimistic as to other categories. So if you see any inconsistencies there, very respectfully, I'd like to ask you. Thank you.
Thank you for the question. I recognize that it may be like inconsistency, but the right to resilience is actually an aspect of the right to life, which is clearly in the convention. And so I don't think it's inconsistent to say that you can interpret the right to life to include the right to resilience. And that's different from wholesale incorporating a right that doesn't exist.
Thank you. Soledad Garcia quiere referirse.
Soledad Garcia would also like to answer your question, respond to your question, sir. If it please the court, and in response to your question, a few ideas were left pending, and I wanted to share them with this honorable court. One of the aspects that I celebrated the most when I read the La Oroja judgment was the recognition of jus cogens as a human right to the environment, which stems also from OC 18, and hopefully you will consider reinforce this as part of this advisory opinion, because as Judge Perez Manriquez said, this might be the scenario in which we should doubt the least that the obligation of states to organize their whole state apparatus to fight the climate emergency and its disproportionate and irreversible impacts is there. And that should be, without a doubt, in my view, a matter of agreement. Nobody could disagree with that in the international community. Together with my colleague Erin, I'd like to submit in writing an initiative that we have been involved with over the last few months, together with a group of scholars, respected scholars from around the globe, that is known as the Third Pact Initiative. It's a proposal for states around the world and for our region also, so that an international covenant on environmental rights be adopted to complement those of 1966. In the first draft that we just finished a few weeks ago, we said that the interpretation of obligations undertaken by the parties under this covenant will follow the following principles: common and differentiated responsibilities, the intergenerational right to live in harmony with nature, and the interdependence between persons and their environment. And there are elements in relation to the right of nature that I believe the court it would behoove the court to take into account. And I would not want to leave out intersectionality, because I didn't hear this in the debate, that the court consider this need to protect frontline communities, communities that are being left without land, without a territory. I was able to visit Alaska and other territories, and it would be very important for that to be taken into consideration as well. Thank you. Thank you for your generosity. Thank you for sending those in writing. In the interest of time, we are over an hour behind schedule. We will be much more strict with the use of time in the afternoon. We're here to listen, but of course we have to keep a certain order and discipline with regard to time. We'd like to thank all participants in this block of comments. We are going to break until 3 p.m. when we will resume. Thank you very much. All rise.